Give it a shot. Good afternoon, everybody. It is Saturday, February 22nd, 2025. My name is Ken Krawchuk. I am the chair of the National Libertarian Party Judicial Committee. We are here today for the hearing in regard to Robson versus LNC. What I'd like to do is first of all go down the agenda
Mr.
and
Chair,
opening remarks. Yes, sir.
please forgive the interruption before we start. Due to some conversations with Mr. Michaela over the past day or so, if the committee doesn't mind, I would request that he address the hearing regarding the current state of the topic of this appeal being the public list. I believe he can provide us with an update as to what's going on.
And what would be a good time for that update before, well, hang on, let me say what the agenda is, and then you can make a motion to amend it. Sound good?
Fair enough.
Thank you much. All right. The agenda, as previously circulated, we called order at 3. We're only 5 minutes late. We're doing better. Next comes up opening remarks from the chair, which are reviewing the ground rules and identifying the representatives for the appellant and the respondent. Then we do the opening arguments, 10 minutes each for the appellant, then respondent, I can talk. After that comes questions from Judicial Committee members, and that will continue till all questions are answered. And the sequence that I have here is Mr. Latham, Mr. Kinsella, Mr. Tarnoff, myself, Mr. Montoni, Mr. Seebeck, and Mr. Stratton. There'll be one round of questioning from each one of them, and then if they want to follow up, we'll do the same sequence again with all those same people. After that come closing arguments, 5 minutes apiece for the appellant and the respondent. And then if there are any final questions from the JC, they'll be in there, and then we adjourn. Now, before I get into my opening remarks, Mike, you wanted to change the agenda?
Yes, sir. Wish to move to amend the agenda to add just prior to opening arguments, a statement by the chair to update the committee on the situation regarding the public list and the archives.
Okay, statement, I guess you mean by the LNC chair.
Yes, sir.
All right. Without objection, we shall amend the agenda. Hearing none, the agenda is so modified. Moving right along, we go into the opening remarks from the chair. First one is just a reminder that we are recording because there was once where it didn't get recorded. Oh, well. Everybody's going to be muted except for JC members. JC members are never to be muted. If you are recognized by the chair or in response to a question, you can unmute yourself or be unmuted. As was pointed out at the last meeting by JJ, we are bound by the bylaws, by the special rules passed by the LNC, and by Robert's rules, and that is the priority order as well. We're not talking about Sharia law or French law or any other jurisdiction. We're just going to stick to those three things in that priority. And if anybody is going to start bringing up anything at length from any other jurisdiction, jurisprudence, or law, I'm just going to call it dilatory and we will move on because these hearings have been dragging out more than 2 hours. I'm just trying to save time. The agenda, as mentioned, is the same pretty much as the last one. And I think that's it. Anybody on the JC want to add anything I might have forgotten for the ground rules? Hearing none. Next up on the agenda is to identify the representatives for the appellant and the respondent. Appellant, what do you think, Mimi?
I'm here and I can answer questions, but Ms. Van Alsten is going to be the primary representative for the appeal.
Would you repeat that name, please?
Jamie Van Alsten, who is here.
Okay, excellent. Okay, and for the respondent, who are the representatives?
Mr. Nikhil had asked me to represent the LNC for this case. This is Andrew Chatterton.
Thank you, Andrew. All right. With that, we move into opening arguments, starting with the appellant. Mimi.
Mr. Chair.
Oops, what did I
Really
miss?
quick, the next
Yeah,
thing is that Stephen Nicola was going to
My
speak.
apologies. But it is anyway, my apologies. We shall turn it over to the LNC chair to make a statement per our amended agenda. Floor is
Thank you.
yours.
Thank you so much, Mr. Krawchuk, and thank you as well, Mr. Seebeck, NJC, for allowing me to speak. I did want to address one of the complaints, which was the LNC business list publication. And I wanted to give a little bit of background and actionable steps that we're taking to try to address this issue. Speaking with staff the other day, it looks like the business list can be retrieved and published to the lp.org website, which I had let staff know that is going to be my intention to do. I did ask if the quote unquote old business list would be available. And unfortunately, it looks like anything prior to the Microsoft 365 transition is lost. So unless there's an archive or backup somewhere, which if I can find something, I will direct staff to go ahead and upload that to the website. If not, then we're only going to have anything past that. Karen Ann's saying it's already on the website. So if there is a copy of it, then and it's there, then great. If we need to find a copy and upload it, fantastic. But the old business list will be uploaded to the website, and anything public as well up to now. So that is my prerogative. The LNC is also passing a motion that currently looks like it will be successful to ratify that decision. And as chair, I've also essentially made that decision also. So we've confirmed and reconfirmed our commitment to getting that published on the website, and I hope that we will be able to do so within the near future. So I just wanted to give the JC that update and let everybody know, what's going on. But it seemed like it was purely a technical issue as to why it wasn't up there, rather than a decision by the board or by anybody else. So we are working on addressing that. And I appreciate your time.
Appreciate the comments. Might save us some time. Okay, so then we move down on our agenda to the opening arguments by the appellant. 10 minutes. Ready, set, go.
Ms. Alstein? Van Alstein?
Yep. Thank you, and good afternoon, members of the Judicial Committee. Thank you for the opportunity to present our appeal today. As stated, my name is Jamie Van Alstein. I'm a member from Michigan, and I stand before you on behalf of the appellant and signatories of the appeal regarding serious concerns about the conduct of the Libertarian National Committee as relates to the conduct of electronic business. I ask for your indulgence. A lot of my responses were contingent on both issues, one being the public list and also the conducting of votes. So some of this may no longer be relevant as I go through this. So today we'll highlight clear violations of our bylaws that impact transparency and accountability within our party, principles that are foundational to the libertarian ethos. Our appeal specifically targets two major issues. One, as just previously addressed, the deletion of the past LNC business and the movement of most LNC business behind a wall of secrecy with limited public disclosure. We are addressing this matter under the jurisdiction of the LP bylaws, specifically Articles 712 and 82, and alleging violations of Articles 714, 15, 13, and 16, which incorporate Robert's Rules of Order. Implications of this appeal reach every national member of the Libertarian Party, as these are not mere procedural grievances. They are critical to protecting our members' rights to access information and participate in party governance. The deletion, I will skip that one. The removal of transparency in LNC actions, where apart from announcing ballot results, that is the votes themselves, the details of our business and any debates have been pushed out of public view. These decisions are not merely administrative changes. They seem to represent a conscious shift away from transparency that undermines our collective governance. On December 31st, 2014, the policy manual amendments made by the LNC deleted the open email section and explicitly excluded debate from electronic ballots. This change effectively removed critical discussions from view, disabling our ability to hold our representatives accountable for their votes, and is a direct violation of our bylaws, which require that all votes and actions be conducted in open session. The specificity of actions here would include discussion or debate and the voting itself. The emails mirroring an in-person meeting where members would be in attendance and witness to all business not prescribed by matters requiring be conducted in executive session. It is essential to emphasize that the Judicial Committee has previously recognized that decisions taken without formal votes, those deemed constructive decisions, should be treated as if formal votes had occurred. This principle is not just an abstract notion, it is necessary safeguard allowing members to challenge decisions that evade accountability. We contend that the actions taken by the LNC, whether overt or not, are indeed appealable. The historical context of our bylaws highlights the importance of transparency. Initially, there were no electronic mail systems. As time and technology progressed, our bylaws have evolved, acknowledging the necessity for transparency in electronic communications, particularly as a way of safeguarding member interests. When the concept of the public email list emerged in the 2012 bylaws, it explicitly stated that notices, proposed agendas, and approved minutes should be archived. This was done to ensure a permanent record, which we allege has now been violated through the recent deletions. In 2020, the related bylaws were expanded to include votes, but importantly for our purposes here today, actions in open session. Moving beyond the historical context, it is vital to recognize the centrality of transparency in the current bylaws. Articles 714 and 15 require that all votes and actions are conducted in open session, unless specified otherwise in the bylaws, emphasizing that executive session should be strictly limited to sensitive matters. If delegates wanted to allow the LNC to be secretive, they would have had no rules specific to executive session, and it would have defaulted to Roner, which lets boards decide. There's no rational difference between email business. The LNC has effectively disregarded these bylaws and standards. If we allow the decisions to be hidden behind electronic walls, we risk becoming a secretive, unaccountable body, unrecognizable from our foundational principles. We believe that the remedies we are requesting are not only justified, but necessary for the integrity of our party. We seek the restoration of accessibility to the historic LNC business list or transfer to the historic preservation. So I look forward to that. And the voiding of the decision to remove all business from public lists, ensuring that actual debates and votes are recorded and visible, with the exception of genuine executive session discussions. In closing, this appeal is about compliance with our bylaws, but more than that, it is about the fundamental principle of transparency and accountability that should govern our party. We urge this committee to consider the implications of allowing the LNC to operate without proper oversight. Every member of the party deserves to know what actions are taken on their behalf, provide input, and hold their representatives accountable for those actions. Together, I request that the JC grant the remedies requested in the appeal by ordering the LNC return to their prior practice of having all votes and action. That is, of course, everything excluding those matters that would fall under executive session exception on the public list, and to restore the previous email discussion list to the extent possible. I don't know how much of that 10 minutes I consumed, but I will thank you for your time, and I look forward to answering any questions you may have.
Thank you. And Thank you for saving us a couple of minutes. Okay, I want to interject here. Karen Ann pointed out something proper that I had neglected to mention. The Libertarian Party is a DC corporation, and if there's anything that is directly related to the DC corporate law, then of course that would be allowed. And we can't get away from the man, can we? All right. That said, let's move on to the opening arguments from the respondent. Andrew, you got 10 minutes. Go for it.
All right, thank you very much. As mentioned, I'm Andrew Chatterton. I am one of the Region 1 representatives on the LNC and responding on behalf of the LNC for this case. As we just heard, the petitioners had sought to overturn two decisions of the LNC. The first about the removal of the previous archive emails, and the second about reversing the policy manual amendment that was adopted that stopped the ongoing practice of keeping the open email list. As I will demonstrate with the rest of my presentation, neither of these appeals have merit under the bylaws. For the first issue, the petitioners have not presented any rule from the bylaws or elsewhere that the unavailable information creates a violation of. That was based upon a policy manual thing that was amended and no longer requires that. However, as the chair of the LNC indicated in his presentation, that matter is already being remedied, and the LNC is complying with the request to restore that information, and therefore the issue is moot, and no action is warranted by the JC. Regarding the second claim, however, contesting the policy manual change that abolished the public email list, the claim is frivolous and is a case that the petitioners are seeking to use the JC to overturn the legitimate actions of the LNC that they don't agree with. Policy manual change was properly voted on and adopted, as is documented in the petition itself with its link to the ballot tracking spreadsheet that shows the votes and adoption. For my verbal statement today, I've truncated a lot of the bylaws and Roner citations that I'll reference, but I have provided in my submitted brief more precise references that correspond along with examples for items that demonstrate the adherence to the bylaws under the current policy. So first of all, to address the concerns, I will examine the bylaw in question regarding electronic mail ballots and look at each element line by line. So this is Article 13 of the bylaws. Starts off with boards and committees may transact business by email or electronic mail. This provides a clear distinction between the business conducted in meetings, which is a session of the LNC, with the rules around that defined in Article 7, versus business conducted by electronic mail that is completely defined in Article 13. The chair and secretary shall send out electronic mail ballots on any question submitted by the chair or co-sponsored by at least 1/5 of the members of the board or committee. This provision is met under the policy. The period for voting on a question shall remain open for 7 days unless all members have cast votes or have stated an intention to abstain or be absent during the voting period by electronic mail to the entire board or committee. This provision is met under the new policy, and the spreadsheet that tracks votes in progress is public. Each ballot tracking sheet is updated regularly, usually multiple times a day when votes are cast on the internal email list. This is in compliance. Votes from alternates will be counted in accordance with previously defined ranked order in the absence of corresponding committee members. This is met, but it's not really relevant to this appeal. The outcome of each motion shall be announced promptly and recorded in the minutes of the next meeting. This provision is also met under the new policy. The spreadsheet that has the vote tracking is updated upon completion of a ballot with a note such that with a vote of X to Y to Z, the motion passes or fails. The number of votes required for passage of any motion shall be the same as that required during a meeting. This provision further distinguishes electronic mail ballots from the business conducted in an LNC meeting by referencing the vote thresholds used for meetings as applying to email votes. Such a reference would be unnecessary if the rules for meetings were intended to apply to email ballots implicitly. Motions dispensed through electronic mail ballots satisfy the requirement of giving previous notice. A further distinction from business in meetings with business by electronic mail ballot, as meeting business typically requires explicit notice in most cases. As demonstrated above, the policy manual amendment adopted by the LNC is completely within the LP bylaws. The claim should be dismissed for the fact that the petitioners have not shown any of these provisions to be violated. I will, however, go through the claims and refute them that the petitioners have raised. All right. In Section 4 of the appeal submitted, the petitioners raised the claim.
Chair, do you mind if I interrupt?
You're breaking up, sir. Try again.
Is there any member of the JC who has not read respondent is just reading his amicus brief / response. Is there any member of the JC who wants to hear what already read, or hear it? I don't need to hear this. I've read the brief. Am I the only one? Would any of the members? I would just ask before, in the interest of time, whether the other members of the judicial are interested in hearing the brief being Mr. Chatterton reading the LNC brief.
Blake, let me start that one off.
I agree.
I'm a pretty easygoing chair, and I'm all for the people either on either side to state their case as they see fit. They have 10 minutes to use as they want, and if they want to spend 10 minutes talking about things that we may already know, that's their prerogative, and that's my opinion.
I'd call for a vote on that.
All right. All those in favor of sustaining the chair, please raise your hands. Or, well, let me go down. Well, let's start with that. You guys can raise your hands if you in favor of sustaining the chair, that they can use their 10 minutes any way they like.
Mr. Chair, I'm not sure how to raise my hand on this app, but I would sustain the chair. This is Mr. Stratton speaking.
All right. So that's 2.
Mr. Chair, as host, I can't raise my hand either, but I would support that.
All right. I see Stefan. I see Rob. Other Rob. Myself. So that's 4 right there. And I
apologize for the interruption.
I sustain also.
thank you very much. There you go. So it's nearly unanimous, close enough to unanimous. All right, chair sustained. We shall move on. People can use their 10 minutes any way they like.
Thank you very much. I respect the concern and all that. I'll try to move as quickly. I would like to proceed with this, given that in case any of the members of the public have not read the full appeal or response with that, but I do appreciate the question. So in section 4 of the appeal, the petitioners raised the claim that the history and the implications of the bylaws demand that business be done by electronic mail should also be conducted in open, similarly to the obligations that meeting business be done in open session, except for limited items allowed in executive session. These claims are also without merit. Petitioners specifically cite Article 7, Section 14 and 15 for their basis of the claim. Both of these sections, however, specifically apply to sessions, which are effectively meetings of the LNC. Roner defines a session as follows. Roner 8.2, in parliamentary law and as understood in this book, the terms defined below have distinct meanings. A meeting of an assembly is a single official gathering of its members in one room or area to transact business for length of time, during which there is no cessation of proceeding and the members do not separate. Session of an assembly, unless otherwise defined by the bylaws, which ours do not, is a meeting or series of connected meetings devoted to a single order of business, program, agenda, or announced purpose. As electronic mail ballots are defined separately and uniquely in Article 13 of the bylaws, there is no reasonable interpretation that would continue. Thank you. As the electronic mail ballots are defined separately and uniquely in Article 13 of the bylaws, there is no reasonable interpretation that consider an email ballot part of a session. Email ballots are not a meeting or series of connected meetings and are specifically in place to allow the LNC to conduct business asynchronously while not in the same place or same electronic meeting. This is fundamentally distinct from the definition of a session or a meeting, and it is therefore absurd to try to apply rules from the bylaws related to LNC sessions, considering them relating to electronic ballots. As stated in Roner 5668 number 2, when a provision of the bylaws is susceptible to 2 meanings, one which conflicts or renders absurd another bylaw, and the other does not, the latter must be taken as the true meaning. Petitioners also make the appeal to the precedent from past bylaws, intents of the delegates, along the lines with transparency. This claim fails on its merits, as Roner 5668 number 1 states, intent plays no role unless the meaning is unclear or uncertain. And as detailed, the provisions of this policy manual are in compliance with all the measures of the bylaws. Additionally, all aspects governing electronic mail ballots are clearly and unambiguously specified in Article 13 of the bylaws. In section 4B, the petitioners raise claims regarding the definition of actions and its distinction from votes as referenced in bylaws Article 7, Section 15. While this claim is already refuted based on the applicability to sessions of the LNC as opposed to the email ballots, it also fails for other reasons. They cite 3 examples from the bylaws in which actions are mentioned, but none of those have any applicability to this case. Among those, they cite the actions of deciding to meet. This is already shared publicly. Petitioners claim that the actions such as sponsoring a motion, asking for sponsors, and asking the chair for clarification shall be included in the publicly shared content. It should be noted that the relevant bylaw starts with the statement that the National Committee shall conduct all votes and actions in open session. Roner 1.1 describes a deliberative assembly, such as the LNC, and its basic characteristics. The introduction continues in 1.4 and states that a member of an assembly is a person entitled to full participation and has the right to attend meetings, to make motions, speak and debate, and to vote. The actions described by the petitioners are the actions of members of the LNC and not those of the LNC itself, subject to the applicability of the bylaw referenced. Therefore, there is no bylaw requirement for those actions to be publicly announced via email ballot. They talked about implicit actions that are done without motions or votes. Those are referenced in Roner 458. The specific usage of those actions without a vote applies when actions are done via unanimous consent within a meeting, and there's no analogous means of conducting business via email ballot, so that also does not apply. I would contest one of the statements earlier that the provisions of the DC Nonprofit Corporate Code related to record keeping have applicability to this matter. And furthermore, Article 7, Section 12 of the bylaws state that the Judicial Committee shall consider the question of whether or not a decision of the National Committee contravenes specified sections of the bylaws. Therefore, it is my assertion that it would be improper for the JC to consider any aspect of statute in reviewing the decisions in this appeal. So, as I have demonstrated throughout the response, the claims raised by the petitioners are without merit. They're attempting to stretch and redefine the bylaws, and they're clearly attempting to relitigate a legitimate and proper action of the LNC because they don't like it. Policy manual amendment was properly introduced, and it was adopted according to the bylaws, and it complies with all relevant provisions of the bylaws. Since the JC is only empowered to assess decisions of the LNC based on whether or not decisions contravenes the specified sections of the bylaws, this appeal must be rejected. To respond to a couple of specific points, there was a general appeal to transparency as called for by the delegates. It should be noted that the claims made in the petitioner's statements were nothing more than assertions that somehow claim that debate is required to be seen to hold representatives accountable, as was demonstrated with the statements in my presentation, as well as the examples documented in my brief. Everything needed for accountability of actions of the representatives is provided under this new policy manual provision. So I will leave it there. Thank you.
Great. Thank you very much. We'll now proceed to questioning by Judicial Committee members. And we had a random drawing. And Rob Latham, you go first, sir. Go for it.
All right. So I guess, and Ms. Alstein, I'll put this question to you. I presume you're taking questions for what we're calling the Robson appeal, even though you're both here. And I want to make sure, is she able to unmute herself? Because she's muted now. Yep. All right. I just saw it going. Just real quick, have you been able to read the amicus brief submitted by Mr. Chatterton?
I was able to open it as I was joining this meeting, so I didn't get a lot of opportunity.
Okay.
And I didn't either, just so you know. I just saw it right as I opened this meeting.
Great. I just want to get kind of the status of folks' knowledge there. What about Mr. Jacobs' amicus? So same question. Mimi shaking her head no.
Same response from me.
Okay. So I'll represent, there's a claim in Mr. Jacobs' amicus, essentially that discussion is akin to debate or comments made in an in-person debate or posted in an online debate. And those things are not actions under our parliamentary authority, under Roberts. So just, do you have any responses to that claim? And you're muted, Ms. Van Alstyne. Jamie, you're muted, so there you go.
Okay. So in Roner, the 12th edition, as noted in Mr. Norton's amicus, 35.6, actions that cannot be rescinded or amended, essentially equates to similar. So we're talking about motion specifically there in Roner, but Roner motions themselves are a part of business, but so is debate. And if discussion is not debate, I mean, what is debate? I mean,
Okay.
we're playing with words now, right? And I understand that Roner is very specific in what it says, but if debate is not discussion, I don't know what it is.
Okay, but I'm okay. So maybe let's just parse that out a little more. So I think Mr. Jacobs is saying is that discussion is debate, but is not action under Ronar. But you're saying that Mr. Norton's amicus says that discussion or debate is action. Is that just where you're coming from there? Is that
I would argue, yes, that debate is a part of business along with motions. And if actions and motions are tied together here, then I would see debate being tied together similarly as relates to business.
Okay. Maybe I'll throw it to Mr. Chatterton. Kind of that same topic. Is there a distinguishing principle between discussion or debate that is not action? And anyway, if you want me to clarify the question, but that's why I think what we're trying to focus on is discussion or debate part of action?
Yes, I think per the citation I mentioned in Roner 1.4, it describes actions of a deliberative body such as the LNC or any of the committees under it. And it clearly specifies that the debate related to an emotion is an action of an individual in that body and not an action of the body itself. The provision in Article 7, Section 15 specifically refers to actions of the body. So I think that draws a clear distinction that the debate in a meeting or related to an email ballot is not an action of the body, and therefore is not subject to the rules even, within a meeting if we didn't have open meetings anyway, but certainly would not apply to, establish a condition under which the electronic mail ballot bylaws should be modified in some way. I'm also not clear on the reference to the consideration about rescission of an action or motion. Generally speaking, I believe that itself would be a motion to rescind something previously adopted or something that couldn't be rescinded. Would have been something that came about through a motion, which would be subject to the transparency that is called for under the open sessions rules or the disclosure of motions and votes under the electronic ballot rules.
Okay, thank you. And actually, let me throw it then back to Ms. Van Alstyne. I hope I'm pronouncing your last name right or how you want to be addressed. But what about that? I think I recall reading that from Mr. Chatterton's amicus that they're distinguishing between actions of the Libertarian National Committee and actions of a member of that committee, and that only the actions of a committee are things that I guess need to be done in the open to comply with the bylaw 7.15. Is there a distinction there that we ought to be mindful of?
I do see Ms. Robson's hand up, and just for the record for everyone, the last name is Van Alstyne to make it easy for everyone. So I would defer to her if she would care to take this one.
Thank you.
Thank you. And just real quick, my last name is Robson, not Robson, since we're making distinctions.
I'll try. It sounds like
it's okay. I don't have an extra letter there, so it's just Robson.
Okay.
Anywho,
my last name's Latham too, not as the chair pronounces it, but maybe it's a regional thing or he's just trying to diss me. Who knows?
No,
It's
wouldn't
all
you know that?
regionalism.
It's
So I just wanted to
unbelievable.
mention that, you know, we're trying to differentiate what's an action, what's a motion. A motion, I think we can all agree on, is an action. Part of a motion is that there's a deliberative process. That's in Ronar. So part of the motion is, in fact, the debate. That's part of the action of the body. It's not just an action of each person who's speaking. It's an action of the body because they're listening to that speaking. That's deliberative process, and then they vote. Ronar or Roberts doesn't really like email ballots. They don't, but they say that if you're going to do it, you need to do it as close to in real time as possible, and you have to have the opportunity to discuss. You've got a period of time to vote, which also gives you a period of time to give your reasonings for the vote, why you're voting yes, why you're voting no. And that also leaves it open to the membership, which is what this is all about. Because during a meeting, a member is able to be in the room and they're able to hear the discussions. They're able to maybe nudge their representative or something to get their attention, but they're there. In Mr. Norton's amicus, if you read that, what this is saying is it would be analogous to a meeting in person where the LNC locks themselves in a room and they do all of the business. And then from time to time, the secretary pops out, not necessarily in real time, just from time to time, pops out and says, we just had a vote. It passed this or that. That's not keeping the membership in an open meeting, which is what all meetings, unless they're, you know, a reason for executive session, should be. So I think to try to make a distinction that people speaking during the debate on a motion is individual actions, I would say it's not, because it's all part of the greater motion. That is what we're dealing with, and that's part of the action. So that, I just wanted to kind of mention that. So thank you.
Okay. And then so the next question, and maybe someone can throw in the chat, and I'll try. So Ms. Robson, I believe there is a provision in our parliamentary authority somewhere that says that organizations can take action that do not comply with the statutory law. And I was trying to look for it in my electronic copy. I'm not easily landing on it. But what about that? I mean, so DC code has been cited. If the LNC was so inclined, couldn't they just say, we're adopting a policy in our manual that does not comply with DC code, and that's okay?
I mean, Jamie might have an answer to this as well. I'm not that familiar with the DC law. I have to be honest with you on that. Although I believe that law always supersedes bylaws. So you can't just say, I don't want to deal with any of the DC laws that my corporation is under, so I'm going to put in the bylaws that I don't have to. I don't think that's the way it works. And in Roberts, they actually do put legal authority above that. But would it be possible for me to, because somebody here knows this far more than me, and that would be Ms. Harlos, the secretary. Could I defer to her for that answer?
Sure, and in the chat, it was thrown up 23:6 in Roberts, talking about breaches of order. I'm looking through there. Any action taken in violation of applicable procedural rules prescribed by federal, state, or local law. Now, that's not the one I'm thinking of, I'll just say, because I want to say I saw something else that suggested that an organization could enact bylaws that still contravene statutory law. So I might be looking to something different there.
Excuse me, Rob, could you please read the rest of 23:6?
It's fairly long. So where do you want me to start from the top?
Well, just to finish the sentence that you started there.
I read it. So it was 23:6, and then there's a sub C. And just to put it in context, I'll start with the lead-in sentence. So it says, in such cases, a point of order can be made at any time during the continuance of the breach, dash, that is, comma, at any time that the action has continuing force and effect, dash, regardless of how much time has elapsed, period. Oh, instances of this kind occur when, and then jumping to C, any action has been taken in violation of applicable procedural rules prescribed by federal, state, or local law. So that's just that piece. But
All right, thank you.
I want to say in my review of Roberts, I had stumbled across, which I thought was unusual, but we're in unusual territory on some of this, that an organization could decide to choose something that was violating the law. This is not the language I'm thinking about. I don't know if anyone wanted to contribute to that. Or Mr. Chatterton.
Well, I think
Ms.
Ms.
Harlow,
Oh,
if
Ms.
you don't
Harlow.
mind, Ms. Harlow.
Yes, please.
Yeah, that's the only section, Mr. Now I'm confused if I'm pronouncing your name right, Rob. No disrespect, I just don't want to mispronounce your name. That's the only section that I'm aware of. I don't claim to have the whole book memorized, so I learn something new every day, but I think that's the only section. But the citation in the petition, from what I understand, isn't to claim that I think it's arguable whether that's procedural, but I do think it probably is procedural. It was just to show how DC law defines the word action. And since we are under DC law, it's important to see that they view actions as other than votes. And just to correct two things, the bylaws prior to, I think it was 2020, said all votes need to be in open session. So that's without question. They added the word actions. So actions has to mean something more than what was already required. Already votes and the results of the votes were required prior to 2020. In 2020, they added the word actions. It has to be, it needs to mean something different, otherwise it's redundant. And the idea that bylaws can't render other areas absurd is absolutely correct. If the LNC could just choose never to meet in person or by electronic means again, and thereby make everything secret, that just rendered absurd the executive session portion. And note that votes could never be had in executive session. So that is referring to what? Discussion and debate. So I would say, yes, there's an absurdity rendered here, but it's not in the part of Ms. Robson.
Okay, and I see Mr. Brown saying an organization can violate substantive law but not procedural laws. So yeah, I still want to track down that quote just to help inform our decision making here. Actually, I see Mr. Chatterton's hand up, so I want to kick to him. I want to add some more information kind of to my question that was inspired by Mr. Jacobs' amicus, and then I'll certainly go back around the horn again. But he has this second. It's on the bottom of page 2. I can maybe start at page 3. So he says that there are certain actions that are not votes, and he talks about them being similar to debate, but he says some actions that are not votes, talks about points of order, approval of the minutes. So they're still actions of the assembly, but they don't require votes. So question is, what about that? And then just Mr. Chatterton will come to you kind of on this topic, and then we'll go back around the horn again.
So thank you very much. I think there was several points discussed, but I'll try to keep it as concise as I can. So the first was regarding the reference to the DC nonprofit code, and if that has implications, particularly on the definition of actions. So the first point of that is that I don't believe there's any contradiction with what has been stated in the case regarding the definition of actions, because the nonprofit code reference specifically calls out the actions of members as needing to be recorded. So this is not a distinct definition of that. It specifically delineates all those different areas of different aspects that are required to be recorded. It doesn't say that all of these things are actions separately. It says a record of all actions taken by members. So it has a wider applicability. This is furthermore, it is not any requirement stated in this citation about the disclosure of these. It's saying that the corporation is required to keep those. Our bylaw does not make any reference to saying it must disclose or publish in real time the items that are required to be kept under the DC corporate code. I would further, I'm not aware of anyone here. These are my plain text interpretations of that. I'm not a lawyer. And I'm not aware if anyone in this call is a lawyer that practices in DC that would be able to make a more substantiated assessment of that. But I don't believe that this provides any contradictory claim to what has been raised in the appeal. I would also like to address the last claim from the secretary about an absurdity that is created by the ability to conduct business by email, as though that would somehow exclude or render absurd the considerations around conducting business in a meeting. I don't think that's a strongly merited statement, because our bylaws permit either business in a meeting or business by email. It doesn't make any distinction of that, and we have a regular standing schedule of special meetings and regular meetings that occur throughout the year where business is conducted. The fact that we are also allowed to conduct business by email under separate rules of that from a business meeting does not render absurd the provisions that apply to business conducted in a meeting.
Okay, maybe going back around the horn, do the petitioners want to speak to that issue?
Jamie, do you have anything that you'd like to speak to on that?
I just wanted to know that again, that the allowance to conduct business and votes via email does not preclude or limit specifically what business is. The only limitation is the matters that can be taken into executive session, discussed in executive session. So I would refer back to Mrs. Harlow's statement regarding the absurdity of the bylaws, discounting the DC corporate law or code there, that it would render an absurdity in that case.
Okay, and then I'll just, yeah, because I'm trying to look through this as well. I do have the DC code up, and I'll also represent, I'm not licensed to practice law in DC. Don't take anything that I say as any kind of legal opinion on how DC law or code works. There is a definition section, and sadly, the word action is not defined there. I'll just scroll up for people who might want to look on their own. It's 29-401.02. But I will point out, so going back to this 29-413.01 corporate records, and it's cited there, this sub A in the petition. So there is this requiring a record of all actions taken by the members, board of directors, or members of a body. So what about that? It sounds like there may be an argument here that by talking about members, that broadens the bylaws requirement that it's just the board, just the LNC. So what about that? Maybe I'll throw it back again to the petitioners, and then I'll come back to Mr. Chatterton.
Well, that just defines that requirement, but the bylaws themselves require more. So
Well,
it expands on that, right? So if
well, I'd say it's almost I guess my question's assuming that it's kind of the reverse, that the bylaws require just a record of actions or votes by the LNC. The DC code says not just the board, but its members and the corporation. So, because I don't think we have members in the party bylaws, but we do have that in the DC code. So that's kind of my question. Are you saying that maybe? Anyway, that's my question. Is the DC code broader than the bylaws, and that's where maybe you're coming from, in that it all just needs, all actions, even of members, need to be memorialized and made public?
I would say that DC would require that, but again, for our purposes here, those are members of the LNC, which is what is defined in the bylaws. And I see Ms. Robson's hand up, so I would defer to her if she'd like to add to that.
Oh, see, you were right the first time, Van Alstyne. You said Robson, and then you went
Yep.
Robson. And
Yeah, that was my mistake.
since I'm a Rob,
It's
it's
okay. I'm Robson.
I'm
Call
used
me
to it.
anything. I don't really care. So I was just going to say, yeah, I believe that you're right that the DC law takes it a step further. I would then also argue, though, that I don't think that the bylaws don't, because it does say actions, but it doesn't say. I still believe that all of the actions for the motion, whether it's made by, debated by members, is still part of the action. But I believe that what you just read in DC law, which I agree, or which I admit, I wasn't as familiar with that, what you just read, because I'm not a lawyer at all. I'm an engineer. But I would agree with you that I think that actually also even bolsters the case that it needs to be all of the actions of the members in terms of these. And so I agree with you. And I think that just after the fact, putting out votes with not even knowing in real time how the people voted. And by real time, I mean, emails are real time. They go through the public list in real time. The spreadsheet is only updated when the secretary is available to update it. So that's not real time. And I would say that all of those are actions that are supposed to be available to the membership.
Okay. All right. Thank you. And I've been speaking with Ms. Also, how about you, Mr. Chatterton, on this?
Yes, I think there are several points that are being kind of glossed over in this matter. So first of all, I think all considerations of the specific application of the provision for votes and actions to be public, being limited in definition to sessions of the LNC, which I clearly demonstrated, email ballots are not sessions of the LNC. I further think that with the consideration of the corporate records provision of DC law, that there's a leap being taken by the petitioners here. Whereas the DC corporate law requires that those records be kept, I'm struggling to find the connection that has any applicability on how those should be published outside of the corporation. As far as I'm aware, the DC, the nonprofit corporation that is the LNC exists consisting of simply the members of the LNC as directors of that corporation. So the members of the party that exist under the bylaws are not members, under my understanding, of the corporation, and therefore I do not believe have rights to access the corporate records of the corporation. So regardless of whether those records are required to be kept by the LNC, there's a leap here in logic that I don't believe is substantiated to say that that would justify or expand the definitions of our disclosure requirements under the bylaws in any way that would be meaningful to the consideration of this appeal to the JC. I think that was everything I had to respond, but furthermore, though, I still would reemphasize my previous point that the listed items of records to be kept, I don't think modifies those definitions or influences the interpretation of those definitions on the bylaws, as it is explicit that they record minutes of the meeting of its members, aka minutes of the body, of its board of directors and any other designated body, a record of all actions taken by the members. So that would cover those to be kept in record, which they are kept in record internally. And the reference to, actions taken without a meeting like we have done is our items are done by email ballot, which is documented and disclosed exceeding those requirements. So I don't see why there's any consideration of this. And furthermore, I still don't see any justification of why, even if the applicability of the law would supersede our bylaws clearly limit the JC's role in this to considering whether an action or decision contravenes the bylaws. So even if it did contradict, which I don't believe it does, I don't believe the JC would have the authority to decide based on that matter, because it's very specifically defined in Article 7, Section 12, that the JC can decide based on whether an item contravenes the bylaws.
Okay. And I saw a hand up and I saw it taken down. So, and I apologize if this is duplicative, but it was just a question I had on my list, and we have kind of touched on it a little bit. But it's again, basically, is there a difference between our bylaw 7.15 talking about actions and the DC code requiring a record actions. And so just I'm seeing that word, and that seems to be kind of where a lot of this appeal rests on. Do you want to speak to just, is there a meaningful difference that we should be paying attention to as a judicial committee on the bylaws meaning of that word actions and the DC code meaning of that word? And just I'll turn it back to Mr. Chatterton since he has the warmer seat.
I'm sorry, I was reading one of the chat messages. I didn't catch the clear, full question there. I apologize.
Sure, I'll repeat it. So it's just, should we as a judicial committee make anything in terms of a meaningful distinction between actions as it's used in the bylaws in 7.15 or the DC code, or are they kind of the same?
It appears to reference, similarly, but I think the requirements about what is done regarding the actions is distinct, and I think it's only the requirements for actions under the bylaws that are applicable to this hearing. So I think those are appearing to define matters similarly. So, as I said, that the actions that the petitioners are seeking to have disclosed on the public list are actions of the members. I think they would fall into the required records to be kept, which all of those email communications are kept by the LNC. We have an internal email list that documents those, and those are available internally, but not disclosed publicly. So to the core of the question, I don't think there's a significant distinction in those definitions that I'm aware of, at least without being knowledgeable about DC law. But I don't think the DC law provisions apply since it's only about keeping of records, not disclosing publicly.
Okay. And to our petitioners, any response to that question or issue?
I just wanted to kind of connect this to something that the respondent brought up earlier as relates to this particular topic, this discussion and the DC code. And that is the fact that if the recent article or reported by Third Party Watch is accurate, there was also a
could you back up a second? Recent article, say that again. I'm not sure I'm following you.
There was a recent reporting by Third Party Watch regarding a motion to seat Mr. Jacob Bradley out of Texas in the vacated at-large position instead of Mr. Malagon. The only thing that was published to the public list was in regards to the matter of Mr. Malagon. Members were not made aware that there was another motion, which I think we're all in agreement here is an action, which should be transparent, was made. And of course, members did not have an opportunity to address that with LNC members or see how that business was resolved.
Let me throw that. I think maybe that's a nice, well, I wouldn't call it a hypothetical because it sounds like it's an actual thing. Maybe Mr. Chatterton, can you use that example as kind of teasing out how this bylaw and the DC code working in conjunction together should apply? Should this motion be something that is, I guess, made public in connection with 7.15 sooner rather than later, or how does that work?
Yeah, I can speak to that. So with that case, we had the situation of two different motions to fill the same vacancy. The motion to appoint Mr. Malagon was submitted prior and was co-sponsored and was in progress. And it was ruled prior to the co-sponsoring was completed, it was ruled out of order by the chair because there could not be two separate motions to fill the same vacancy. So that motion never met the requirement under Article 13 of the bylaws of being co-sponsored by at least 1/5 of the members of the board or committee. And therefore it was never published on the public list. So that was fully in compliance with bylaws under Article 13. I believe with consideration of the DC provision, that would be required to be kept record of as an action of members of the board. But there's no requirement there that I see for that to be published.
Okay. And then, I see hands up by Ms. Robson, and then since it's your appeal, I don't know if we want to defer to Ms. Harlos to speak to this further. But we'll just, I'll go to you, Ms. Robson, and then if you want to let Ms. Harlos amplify, please let us know.
Okay, all I was going to say is that it is my understanding from Third Party Watch, because that's where I saw it, that the motion for the second possible appointment was fully sponsored, and that is an action. I understand that, well, I didn't know this until just now, that I guess Mr. Michaela called that out of order. But okay, and I'm not going to get into that because that's not part of this appeal, but I would believe that it wouldn't have been out of order because it would have been a competing motion. But again, that's something that the membership should have been aware of regardless, because there was two motions made for two different individuals for the same seat. And this is a seat for an at-large that the membership itself had elected at convention. They should be aware of who is up for that seat and be able to chime in with their region representatives and their representatives in general to state a preference. And so I think that that absolutely would be in violation of both the bylaws and DC law, not letting that be made public to membership. But I'll defer to Ms. Harlos for anything further.
Go ahead. Probably need to unmute.
Okay, this shows a difficulty because everything's considered confidential. I can't tell you what happened. I can just tell you that inadvertently, and I believe it was completely inadvertently, Mr. Chatterton did not state completely accurately what happened, but I can't tell you.
Okay. I don't know if Mr. Chatterton wants to speak further to that, or because if not, that's all my questions.
I'm not clear on what would be confidential in that, but the main consideration with the overall argument is if this was, not properly not disclosed, I don't think this constitutes a violation on the part of the policy. This would be an execution of the policy at the most. So I don't think that this would have any bearing on the merit or not as far as a compliance with the bylaws of the overall policy, but merely an adherence to that. And that could be appealed by any board member on that ruling of the chair, and it was not appealed in that circumstance. So that was generally handled through the proper procedures. If there's a grievance over that matter, as reported by the content from the Third Party Watch site, then that would be grounds for a separate appeal if it's so believed. So I don't believe there's any merit to that either, but that would certainly be something that I think would be within the discretion of the JC to take up if that was viewed severely enough that was the case. But with I think the good faith efforts of the LNC members, I think that was conducted in line with the rules of order. That it was considered that the chair ruled the motion out of order at the time that it was sought for co-sponsors, and it never achieved the required measures to be published on the electronic ballot list as is required under Article 13. So I don't think that represents either a violation of the bylaws or an indication of this policy being in violation of the bylaws.
And I see Ms. Robson has her hand up. So to you.
Yeah. So I just want to say two things. One, again, Mr. Chatterton is saying the sequence of events. That's not what I believe that I read on Third Party Watch, but that's regardless. Part of this is the reason why we don't know is because we can't know because it's behind a wall of secrecy. And I think what Ms. Harlos was saying is that because all of the lists for the votes and things that happen in the LNC is considered a private internal list, she can't speak to it because it would be considered confidential. And she should be able to speak to it because it's something that happened and she's the secretary, the recording secretary. But I believe what she's saying is because it's behind a wall of secrecy, she's not allowed to say it, which I think is a problem in and of itself.
So, I mean, I'm not going to ask this as a question just rhetorically as I pass the baton to another committee member. I mean, I guess, is that secrecy issue a policy matter or is it a bylaws matter? And maybe it's both, but I think that's what we're wrestling with. But Mr. Chair, I think I've concluded my first round of questioning, so I'll pass the baton.
Yes, thank you very much. And some good questioning it was. All right, next up on the list, I have, if I'm pronouncing it correctly, Mr. Kinsella. Stefan, go ahead.
It's Kinsella in Ireland.
Kinsella.
No, it's Kinsella here.
Great.
No, I have no questions. Thank you.
All right, thanks. Moving down the line, Mr. Tarnoff, and be nice.
Okay, I was going to take a very short break while Mr. Kinsella spoke, but
You want me to come back to you?
no, that's okay. The first question I would have was Mr. Chatterton, I think he opened up with the LNC business list publication. Old data was lost. Is that do I have that right?
No, I think that was regarding the previous list. I think Mr. Nikela stated that information from prior to the Microsoft migration was lost. I'm not familiar with those technical details, so I would certainly defer if Mr. Nikela is still on the call to clarify that, however.
Is that a complaint of the appellant? Is appellant complaining about the fact that data was lost? Is that a problem that we have to address here today?
The linked item in the petitioner's appeal points to the list that was used after the Microsoft migration. So there was a separate list that was, I forget the specific name of it, but the item business list, LNC business list public group was established after the list. And I believe that is the one that was linked to in the petitioner's appeal, but I'll defer to them if they have a contrary.
Yeah, I would ask the appellants that, Ms. Van Alstyne, did I pronounce that right?
You did.
Okay. Or Ms. Robson?
Specifically, we were specifically talking about the one referenced in the appeal because the actions of the LNC specifically affected that particular list. We do know that there were technical changes or technology changes. I mean, there is a bylaws requiring that all the lists be made available or archived somewhere, so that loss of a list is of concern. But specifically, we're talking about the one that was implemented immediately after the change to the Microsoft product, and went missing, whether overt or by mistake, went missing after LNC took action, the actions that we're speaking about here in our appeal. Hopefully that clarifies.
Are you saying that because the LNC took action that, according to you, were in violation of the bylaws, that data was lost because they took this improper action?
I am not asserting that. We are asserting that the lists are unavailable. And that is not in relation to member action. It is related to some action that the LNC took, whether it be from technology challenges or an explicit and overt attempt to remove it from view. I'm not implying the motive. We are just saying that list is missing. These lists are missing, and it's related to the LNC.
Okay.
Can I just add something really quickly? I believe that what Mr. Nikela said is that part of the records that we were talking about are being put back, or they may have already been put back onto the website and onto Alpedia, and that the LNC is taking action on that. I believe he also said that there was there was an issue where they lost some stuff. If it's lost and truly can't be found, I mean, I'm not asking the JC to wave a wand and recreate data that's missing. So no, if they're making the corrective actions of putting the list that they have from the past up, and they can't put something up that doesn't exist, I wouldn't ask that the JC rule on that. I think that part of it is moot, so long as what happens that Mr. Nicola said would happen happens.
I'm just trying to, I guess, plumb the depths here of, you know, if the LNC, if there's any allegation that the LNC, that this accident happened because according to you, the appellant, that the LNC was doing something that it shouldn't have been doing. I'm just trying to plumb the depths of the you know, accusation here. But it seems, if I'm not mistaken, that this is just an accident, was not the result of being involved in any kind of malicious activity, according to you.
Right. We were saying initially when they didn't publish it, they for whatever reason didn't publish it, whether it was constructively or not. They didn't do it. Now they're correcting what they can correct, and if it's gone, it's gone. So yeah, we're not saying that it was, if the stuff is gone, if it's truly they can't find it, it's disappeared. We're not saying that was malicious. No.
Okay, it seems like a lot of the appellant's argument has to do with policy. You know, as much as maybe some of us on the JC would agree or disagree with the policy or want the LNC to adopt a certain policy, that's really not our role to determine policy, right? It's our role is specifically stated in the bylaws as determining whether some action by or decision by the LNC violates the bylaws. So, you know, I'm not completely clear on what the bylaws violations are in this case. Now, you had 2 points in your brief. Do you agree? I know Mr. Chatterton said that your first point in your brief is moot at this point, but I don't recall you agreeing with that. Would you agree that the first point in your brief is moot and that we don't need to consider it?
In regards to the list, I would agree.
Okay, so we don't.
The availability of the missing list, yes.
Okay. As for the second point, let me just refresh my memory on that one. Slow computer. Well, what is the claimed violation of the bylaws in your second point, that you moved all businesses and actions of the LNC with the exception of the announcement of an email ballot and its results behind a wall of secrecy? Is it that it violates which section of the bylaws?
That would be, as stated, 7, 14, 15. There's some direct correlation to 13 and 16, but I would say that specifically we're stating that the bylaw requires all votes and actions, and that debate is a fundamental part of business, which this is what is being addressed here, and that the removal of that essentially violates our bylaws.
I guess what I'm asking is, is your only complaint that they have made an amendment to the policy manual? That,
no,
you know,
the policy,
or do you allege that the LNC is actually actively violating the bylaws by its actions?
we're alleging that they are actively violating the bylaws. The policy manual only was entered to more fully comply with those bylaws and to kind of codify what had been in practice on the LNC since 2014. But the bylaws requirement of having all business votes and actions is what we're saying is the violation here. If you're giving us the results of the vote, but not the actions, the votes and actions associated with business, which is being conducted via electronic mail instead of in lieu of in person, is a violation.
Okay, then let me ask Mr. Chatterton, what types of business are being conducted? You have in-person meetings. Do you also hold electronic meetings and email ballots? I mean, I want to get a sense of like what kinds of business you're doing, what kinds of proceedings that the LNC is involved in. Not everything is in person, obviously. I know that there are some
Yes.
email ballots, but are there also video conferences, teleconferences?
So the LNC conducts regular in-person meetings, as you mentioned. There's typically monthly special electronic meetings that are conducted, and those are held usually in the first, I think, Sunday of every month. And then there are the email ballots, are the formal means of conducting business. There's been assertions about the wall of secrecy and all that, and I think those are based on just a fundamental misrepresentation of what's actually happening around the email ballots, in that they're asserting that these ballots are coming out simply when the motions are concluded and saying this was the result, which is simply false, as I laid out in the beginning of my presentation in the opening statements. Those notices, as required under Article 13 of the bylaws, are sent when a motion receives the sufficient number of co-sponsors or sponsorship by the chair. And then as those are going, votes are updated in near real time, obviously not completely real time, and it is based on the availability of the secretary. But the in-progress votes are documented and presented publicly throughout the 7-day voting period. That shows votes in progress. It allows transparency to see who is voting for or against a motion. Members of the party have the ability to look at that and see when, if and when a member votes one way or another, they can contact that member and find out their reasoning. They can apply pressure and try to affect that outcome in the normal processes. So aside from that, those are the means of conducting business of the LNC. I understand people don't like that, but these assertions of walls of secrecy are simply not well founded. The considerations of actions being withheld has been firmly established under our governing documents that the actions of the LNC are being presented. The petitioners simply don't like the fact that the actions they seek to see are the actions of the members, and our bylaws make no requirement for those to be made public in the case of email ballots. We have specific requirements for sessions of the LNC, which is well defined in Article 7, Section 15. It says that business conducted of the LNC must be done in open session, but email ballots are simply not a session. I read from the definitions of a session, I think was Roner 8.2, and the email ballots in no way qualify as a session of the LNC. So there's no rational application of those rules to the conduct of email business. And the email business is specifically defined about what the requirements for disclosure are and what the required actions are, and those are all fulfilled under the current policy. So there is no violation of the bylaws with this policy manual amendment. And as you asked, this is simply that the petitioners do not like the policy that has been adopted by the LNC.
Okay, well, let me ask the petitioners. I want to just go through all the types of actions, the types of proceedings that the LNC goes through. Are petitioners satisfied that the LNC is complying with the bylaws in in-person meetings?
In person, I would say.
So in-person meetings,
Yes.
Are they conducting those meetings? Are they open? And are you satisfied that the LNC is complying with the bylaws with regard to in-person meetings?
To the extent that we are aware of all business, yes.
Well, in-person meetings are pretty clear. It's when they all get together and they,
Yes.
meet. So I'm not sure where there would be any secrecy going on. You think that they're maybe going off into side rooms and having discussions that should be open, or with
I'm not
regard to
asserting,
in-person meetings?
I'm not asserting anything. As far as we are aware, I would say they are complying in in-person meetings as relates to business requirements in the bylaws.
Okay, and with regard to meetings by teleconference, I believe Mr. Chatterton said the LNC meets monthly in a teleconference meeting. Are you satisfied that those teleconference meetings are in compliance with the bylaws?
Again, I would defer to the same answer, is yes, to the extent that we are able to ascertain they are in compliance.
So the only issue is really with, are there any other meetings are there any other proceedings that the LNC engages in other than email ballots that concern you as appellants, that where you feel that the LNC is not abiding by the bylaws, is not in compliance with the bylaws? Are there any other types of proceedings? We've spoken about in-person meetings. Those are okay. The teleconferences are okay. We're going to talk about the mail ballots in a minute. Are there any other kinds of proceedings that the LNC engages in that you would find are in violation of the bylaws?
Again, I can't definitively ascertain, but I mean, there are executive sessions which are also clearly defined and separately defined. And I would hope that they're complying, but because of the nature, I can't make any claims.
For an example of why email is a constant open session.
Mr. Norton, could you please mute yourself?
And Mr. Tarnoff, can I just really quickly just
fine with me, yes, if it's okay with the chair.
Piggyback off of what Ms. Van Alstyne just said. I think I said that right. Yeah, we're not alleging that they're doing anything wrong in any other types of business. So as Mr. Chatterton just said, their formal methods of conducting business are in-person meetings, electronic meetings, and email ballots. He stated that. Those are the three ways that they conduct business. We're not asserting that they're doing anything wrong with the first two ways. We're asserting that they're violating the bylaws in the third one, which is very specifically the email motion. And it isn't just because we don't like what they're doing. It's because the bylaws and RONAR and DC law are all very clear that these things should be done such that the membership, not just the LNC is privy to it, but the membership who elected the LNC is privy to that information. And it should be no different than what they do in business meetings that are either electronic or in person. It should still be that the membership is privy to the deliberative process of how they reach the final action, and is all part of action. So I just wanted to piggyback that we're not asserting anything other than that.
Hey, thank you. I just wanted to narrow the issues. So now we're only talking about the email ballot process. So
Rebutted that the session consists of in-person gathering or electronic meeting. And I
Point
said,
of order.
speaking and why? What's going on?
Mr. Chair, can we have Mr. Seebeck mute?
Is that Mr. Stratton?
No, that was Mr.
No,
Norton.
I was trying to get the chair to do some action on that interruption.
I already asked him once.
Thank you, Mr.
He's
Chair.
muted now. We're good. Please continue.
Okay. I'm not sure if that was a relevant interruption or just a disruptive one, but so I would ask Mr. Chatterton. I'm sure now that I've sort of narrowed the issue to only the email ballot process, I want to know what is the nature of this email ballot process? Is it only sending out a ballot and asking the members to return a vote on it, or is there some kind of deliberation going on there? Is there other kinds of business that are done in these email balloting? What is the nature of the email ballot?
So the nature of the email ballot is as defined in Article 13 of the bylaws. And the main actions required for that are sponsorship of the motion, sending out of the sponsored motion, conducting the votes. With this new policy manual change, we made it so that those ballots would only have the vote present on them. Absent a overturning of that by effectively 2/3 of the body. So essentially, if there's a request to include debate on an email motion, then it can be objected by 1/3 of the membership and blocked. So comparable to if 2/3 support it, it would proceed. So in the event that there is 2/3 of the membership that wishes to debate the motion on the email thread, that would be conducted. Absent that occurring, which we have not had that pathway exercised to this point, that email ballots are simply conducted. There is, the counting of ballots, and that is reported on the public ballot tracking sheet by the secretary after the initial motion is sent out at the time that it is sponsored. So any debate or that is established outside of the purview generally of the whole LNC. And there might be discussion between members, which is certainly something that we cannot prevent or anything like that. But we have generally just the ballots are consisting of the votes from individual members or clarifications occasionally and things like that.
Well, in this email thread are those peer-to-peer kinds of emails, or is it in a group?
The email thread is done on an internal list of the LNC. So there is just generally when a motion is sought to be moved by any of the members, they will send an email out to the entire LNC on a defined email list and say that I'm seeking co-sponsors for this motion. Upon co-sponsoring by 1/5 of the committee or sponsoring by the chair, that ballot becomes effective and the motion is moved at that time. And a separate ballot email is sent out by the secretary, which is the official vote collection ballot for that motion. So that is what is directly reported by the secretary. So the secretary takes all the votes from that thread, that specific thread of the whole LNC, and is reproducing them on the ballot tracking sheet, which is what is made publicly available to the members of the party.
So if I understand what you're saying there is no means by which people who are not on the LNC can see, can monitor the email discussion, the email traffic.
Right. The policy manual that's in place has the requirement that just the votes are on that thread. So that is what is put out to the members of the public are the votes.
Well, I understand you just said that
yes, to your question is that list is not accessible outside of the members of the LNC. Sorry for being indirect.
Would it be possible to, is that a technical impediment or is that by choice?
I believe that's by design. The consideration of making just the votes public is basically the enforcement mechanism, I would say, is the publishing of that list. So if people are, including additional comments, those are not made publicly accessible in that. So that is by the design. And I think that basically just is the policy. It is not a matter of bylaws compliance, as I've established elsewhere in my argument.
So if fewer than a third of the LNC members object, then you may have discussion in that email thread other than simply the vote. Is that true?
If it's requested by an individual member and it's not objected to by at least 1/3, the provision is, I think there's a 48-hour period to allow for objections. And if that is not met, then that's automatically allowed.
Okay, would you consider that a proceeding?
That's, I think, still within the conduct of the email ballots. I don't think that is in violation of anything. It would not establish a session, if that's what you're referring. A session is specifically defined as, an occasion when the board members are meeting either in person or in an electronic Zoom meeting, which is still not the case in that event. So in the case that there was a request for debate raised and not objected to, that would still be within the scope of the rules of Article 13 of the bylaws. It would not go over into the rules that go for such as Article 7, Section 15, that states that sessions of the LNC meetings must be open session except for the executive session. So that still would not apply in that case.
Is the LNC entirely hanging its hat on the technical definition of a session?
I think that's a critical distinction in the bylaws. The bylaws are published by the members. They wrote them in that matter that says sessions must be done openly, except for those exemptions. And email ballots clearly do not apply as a session of the LNC. And the bylaws are authored such that the delegation chose to adopt Article 13 separately from the rules about a session. So I think that is a controlling factor in this case. And I think that on its own, that argument alone, I think defeats the entire argument by the petitioners. Absent any other consideration of that, the rules simply do not apply to email ballots.
So you would contend that the fact that they used the word session in the bylaws, that is the same as the word session in Roberts, and since what you're doing doesn't meet the definition of a session, you can that 7.15 would not apply.
Yes, and I would add, supporting that case is that Roberts under 8.2 specifically states that a session of an assembly, unless otherwise defined by the bylaws, is a meeting or series of meetings. So Roner also supports that interpretation. And that would also fall under the argument that I made earlier, that to say that an electronic ballot is a session would make the definition of a session absurd. You cannot apply those bylaws to the conduct of electronic mail ballots. In any case where the bylaws are defining a provision such as electronic mail ballots, that would supersede, but there is not contradictory language in the bylaws. I believe it was incorrectly asserted earlier that electronic mail ballots are addressed in Roner. I don't believe they are. I believe Roner addresses electronic meetings, which we utilize and we hold as defined separately in our bylaws from electronic mail ballots. So trying to draw the distinction separately from that electronic mail ballots exist on their own independently of that is a flawed argument.
I realize this is a rhetorical question, but you are conducting votes, are you not, on the by email ballot?
Yes.
Okay, the rhetorical question. Can you hear me? Am I still on?
Yes.
Yes, okay. 7.15 says the National Committee shall conduct all votes in open session. Does that not conflict with Article 13? Or bring up an ambiguity as to whether
I don't believe so. Is the intent...
the votes by mail ballot are in open session? I mean, it says, you're conducting votes, and 7.15 says the National Committee shall conduct all votes in open session. You're claiming that Article 13 is not a session. Then there's some kind of conflict, right, between 7.15 and Article 13 that has to be resolved. Is that right?
Yeah, and I think that would come down to the consideration of the delegates when they adopted that. So when the section on electronic ballots was adopted, that is clearly establishing a separate channel of doing business. And if you do take the interpretation otherwise, and I think there are guiding rules under Roberts that would dictate on which interpretation should govern in that exchange, I don't think the question would be whether or not electronic ballots should be published. I think then if that ambiguity is to be explored on both sides, it comes down to a question of whether or not electronic ballots can exist at all. That's not the claim that's been raised by the petitioners here, so I don't think that would be in scope. But clearly, when the delegates adopted Article 13, they had the intention to allow votes to be conducted in a session or in a fashion separate from a session as defined under Article 7, Section 15. So the delegates may have contradicted themselves in one way or another, but that doesn't lend itself to the arguments raised by the petitioners here about disclosure of those. It's simply a matter of whether electronic ballots are to exist at all. And I am taking as controlling in that consideration of my argument that the delegates adopted a specific section of the bylaws that defines those. And so therefore, I think it's pretty clear that the intent of the delegation is to allow email ballots separately from conduction of business in a meeting, which is having the conduct governed with the open session versus executive session.
Do you think the intent of the delegates in adopting Article 13 was to create a loophole, a backdoor channel by which business or proceedings could be done in secret? I mean, besides the cases in 715 where there's personnel matters, et cetera, in executive session, do you think that the delegates intended to create a backdoor means for the LNC to conduct votes in secret as opposed to not in open session?
It's clearly not calling for actions to be done in secret. Those actions are fully disclosed when they're done in email. So I think the consideration of whether or not it was the intent to make a loophole is somewhat of a loaded question in that regard. However, those considerations about governing the intent and how that applies as far as controlling matter is very specifically addressed in Roberts in 5668, which I cited in my brief. So if the body would entertain, I would read that in its entirety with sections 1 and 2, not going beyond that, because I don't think that specifically speaks to this matter.
I'm familiar with those sections.
So yes, so I'll then just jump to kind of how that would apply here is that the consideration about whether or not specific information should be disclosed under those provisions in Article 13 is very clear under Article 13. It delegates specific responsibilities about what information shall be sent and published and which shall be not. The consideration of whether email ballots are allowed at all is a separate question, and there is an ambiguity in the bylaws, as you aptly highlighted. 715 does say all votes shall be in open session, which would preclude the existence of any form of electronic ballot. So if it were to be the finding of the JC that those two things contradict, the first statement of 5668, number 1, is each society decides for itself the meaning of its bylaws. But it does make clear the circumstances under which interpretations about ambiguities can be made, and those are governed strictly, and that would not include any judgment that would find in favor of the petitioner's questions here today, because that is not an ambiguous element of those bylaws. So the ambiguity that exists is irrelevant to their claim here, whereas the question at hand in the appeal is simply, does that email have to be sent with additional information, which is very clearly defined in Article 13. The question of whether the rules from 715 apply is not at all ambiguous under our bylaws. Sessions are clearly defined, and the rules in Article 7, Section 15 clearly only apply to sessions of the LNC, which is to cover the in-person or the special electronic meetings. So I think that is very clearly laid out under the rules of interpretation on how it applies here. And I leave the further questions that matter to the JC to consider, if email ballots should be allowed at all. But I think the intention of the body of the delegation was that they be allowed.
I I would agree with that. Is there any way to construe 715 and Article 13 together so that neither is rendered moot or in conflict? Is there any way to remove the conflict between 715 and Article 13 by, for example, I would ask this of appellants, but if the proceedings that took place under email ballots were broadcast or visible to people who want to see them, do you think, I'm going to ask appellants after, but do you think that would satisfy the conflict between 715 and 13? And would that be something that's possible to do?
Is that a question to me or the appellants? Sorry.
It's to you.
Under the current definitions, I don't believe that there is any way to rectify that. As I stated, I don't see any way that an email ballot can be construed under the guise of a session. I think that's a critical flaw for that. If it were desired to bring those into unison, I think that it would require a bylaw change by the next convention or future convention to make specific that those rules would apply separately. But as they are written now, and as is cited, in 5668 number 1, that if there is not a unclear writing of the bylaws, there is no opportunity for interpretation, and there is no ambiguity between what is called for in an electronic mail ballot and what exists under this policy. Those are completely in alignment, and therefore it is my opinion that if email ballots are to exist, this policy manual provision is completely in compliance with the bylaw.
Well, you did cite Roberts before that said that the definition of a session is as it is in Roberts unless it is defined differently in the bylaws. So couldn't there be an implicit different meaning of session? That couldn't it be argued that by adopting Article 13, there's an implicit expanding of the definition of session to include the email balloting process?
I don't believe there's any indication in the text of that, and I think there are several elements in the text of Article 13. Well, I think there's several elements in the text that suggest against that implicit expansion of the definition. Several of the provisions, as I highlighted in my opening statement, are specifically either stating that rules from meetings do apply where they do, such as the consideration about vote thresholds. And then there's the consideration that email ballots are separate or have separate rules applied to them with regard to notice. So I think there are clear distinguishing factors in that Article 13 bylaw that would suggest, contrary to that was not intended to be an expansion of the definition of a session, and instead was, I think, clearly intended to be just a separate avenue of doing business.
Well, couldn't those statements also be evidence of an intent to expand the definition of a session? I mean, they're talking about period for voting on a question and what the vote threshold would be and all of that. Seems that could be interpreted as trying to cajole some of the normal aspects of a session. So that might be part of the implicit redefinition of a session. Let me ask appellants, if the email process, the email balloting process were visible to observers, maybe that they couldn't post to the list, but a copy of each email that's sent by anyone on the LNC, for example, were also sent to, to an archive or to some read-only list, would that satisfy appellants that the open session requirement of 7.15 is satisfied? Or if the ability of the LNC to expand the voting to include debate, if that were taken away and that they can only do votes, would either of those two satisfy the appellants that 7.15 is now being complied with, if you follow what I'm saying?
I do. And would you mind if I pass this to Ms. Harlow to answer?
Go for it.
I don't mind if the chair has no objection.
I have no objection to anybody calling in anybody. I'm a pretty easygoing guy. We know that by now.
Just making sure.
Thank you.
Hey, thank you. And Blay, I will get to your question, but there was a whole lot covered by Mr. Chatterton that we're not getting to respond to. And I say we because the chair of the party knows that I'm on the side of the appellants in this one, which is why I told him when somebody needed to argue for the LNC, please don't ask me, because I do not agree with the LNC on this. This will be made public, but just an FYI, and this is important to the JC, Mr. Chatterton brought up an important point that debate is presently disallowed in an email ballot unless 2/3 of the LNC agree. Well, that just raised a very important point for this appeal, because a basic right of membership is to be able to debate. And the only way that can be taken away is through disciplinary procedures. That entire policy manual provision, I just gave notice of a point of order that I'm going to be raising at the next LNC meeting. You cannot prohibit debate. That is in violation of a basic right of membership, unless Mr. Chatterton is going to claim, as he seems to be claiming this isn't really a meeting, that not all LNC members have a right to vote because this isn't really a meeting, so their basic rights of membership don't matter. I think Mr. Tarnoff had it exactly correct that delegates in convention don't understand the technical meaning of session, and they also knew from 2014 through 2020 that the practice of the LNC followed what they obviously understood, that everything would be open except for things under executive session. They had no reason to think there would be another interpretation to object in convention and amend the bylaws, because that had been the practice of the LNC. If this appeal is not sustained, in either event, I think the delegates need to amend the bylaws, but I think there's going to be a big backlash because I do think the intent of the delegates is clear. And I think Mr. Tarnoff was also correct. I think it is absurd to say that if the appellants are correct, then email ballots aren't allowed. Obviously, the delegates and everyone has been fine with email ballots. So when you're looking at potentially interpreting the bylaws where it seems like there would be a clash and one would render an absurd result, which I already said it would render the executive session portion absurd, I think rendering the idea that we can't have email ballots when there's a section entitled email ballots that creates this potential conflict that Mr. Chatterton said, that you have to harmonize those in a way that's not absurd. And the way to harmonize those in a way that's not absurd is the relief requested by the appellants. Mr. Chatterton mentioned procedures that I believe he said this utterly inadvertently. I do not believe he is trying to mislead the JC. But this whole idea of a voting chart that members can see, that's just something I do. It's not required anywhere. I could stop doing it tomorrow. It's just a custom. There's nothing requiring that. So that's no protection for members whatsoever. And if, say, somebody makes a motion, say I make a motion tomorrow to make the official name of the porcupine George Quilly's, just to cite a recent controversy because it's not an official name. And what if members were really in favor of that? But after 2 days, I got no co-sponsors. How would members know to petition their regional representatives to co-sponsor that motion when they don't even know that the motion was made? Because it was never publicly announced. And I think that is an issue. But something I wanted to reach you all or draw to your attention, 1.4, a member in assembly in the parliamentary sense, as mentioned above, is a person entitled to full participation in its proceedings. Emails are definitely proceedings, and I think they're definitely actions. That is the right to attend meetings, make motions, and speak and debate. You can't violate these basic rights. They are all part as a coherent whole that you can't take away one part of them without destroying the entire entity, in that a motion flows into debate unless it's foreclosed by a 2/3 vote through a motion to call the question, and then flows into a vote. It's one whole piece. You can't pluck out a thread and say that you're complying with openness. And I do believe Ms. Van Alstyne has something to add, and I thank you, JC.
Please, if I could just speak for a second on that. Thank you for the information. I would, to the extent that you have said I am right or wrong about something, is not my intent to argue. I'm just trying to ask questions. I don't believe you answered my question. I can restate the question. Are you, and I would want to know, are you able to answer it, or should somebody else take it on? My question was in regard to something you did mention, which is construing conflicting provisions so that they are as much as possible in harmony with each other. Would it satisfy appellants if the email balloting process were, if all of the email traffic back and forth in the email balloting process were copied to an external list whereby people would be able to monitor it who are not on the LNC, or if the debate, and I understand your parliamentary point about limiting debate, but that has nothing to do with what we're discussing today. It's an interesting question, and I certainly don't want to deal with it right now, though. But if that provision were eliminated, or if the debate were allowed, but the email traffic were copied to another list that could be monitored, would either of those or both of those satisfy appellants that the bylaws 7.15 are now being complied with? If you can answer that question, fine. If not, I would like an answer from someone else.
I think Ms. Van Alstyne will have a supplement, but I can answer that. The past practice of the LNC until October 2023 was exactly what you described. All of the debate and votes were on a publicly accessible email list, and I believe, I don't want to speak for Ms. Van Alstyne, that would satisfy the appellants. I hope that answered your question, Mr. Tarnoff. Please.
It answers half of it, but that's fine. Either one of those solutions. I proposed two potential solutions, and asked if either or both would satisfy appellants that the LNC is now in compliance with the bylaws. And you said that one of them is something that was done in the past, and that if that practice will return to, or if some other practice whereby people were allowed to monitor all the email traffic occurred, that would satisfy appellants. And so now I would ask Mr. Chatterton, if he's able to speak for the LNC on this, would that solution satisfy appellants, or would you insist that your email voting procedure must be done in secret?
I would reject the assertion that our claim is that it must be done in secret. It is not. Our votes are published in real time, or near real time, and the motions are disclosed when they start and when they finish. So the assertion that from the appellants that this procedure constitutes business in secret is a flawed assertion. However, though, I would absolutely assert that the consideration to have that list published would be akin to our old policy, and that is simply a matter of policy that the appellants disagree with. They have not demonstrated any element of that being within a violation of the bylaws. And to further establish that, in response to the arguments from Ms. Harlow, she stated about the obligations or the considerations of the intent of the membership at a convention. I believe Ms. Harlow has worked with me specifically in Michigan on matters where, the intent of an implementation of the bylaws fell because it is worded specifically according to, the definitions provided in our governing documents in a way, even though it wasn't what is intended, it is very clearly what is written. And in addition to the rights of members that have been called out by others, it is additionally a right of members to be able to look at our bylaws and where they are clearly defined to have a clear understanding. A new member to the party cannot know reasonably what was the intent of delegates several years ago. So if even if that intent is contrary to what is actually written, a member of the party that wasn't around at that time has every right to believe that what is clearly written is the rule of the party. And what is clearly written in our bylaws is that the consideration of open sessions apply to sessions of the LNC and do not apply to that. And the rules governing our email list are clearly defined and not being violated. So it is every right of the LNC to enact this policy as we have done, and I would stand by my assertion in defense of that policy that it is not a violation of our
And
bylaws.
I understand that's your assertion. I'm not asking that. I'm asking whether or not this change on the part of the LNC, if the LNC were to make such a change, would that be something that the LNC would be willing to do? It sounds like you would not.
That was specifically, the motive of this change. To have that list publicly viewable was the implementation under the old policy manual that the appellants are asking to have reinstated. So we intentionally changed.
I apologize. I mischaracterized that as doing business in secret. Could you tell me? Could you tell me what is?
Blake, excuse me, Blake. I'm going to interrupt here. You're doing a lot of what we call an IT solutioning. You're saying, would this help you? Would that help you? Our goal here is not to ask or to devise some sort of a solution to the situation at hand or say what the LNC should vote or not vote on, or being hypothetical like that. I think you should limit yourself to questions just about what they believe and not try and plan out some future course. Because you've been going on for quite a while. Would you agree to this? Would you like that? And I would ask you, can you please move on to?
All right, I'm almost done anyway. Could you elaborate as to what the difference is? How is doing business, doing proceedings in a way that is not visible to the membership different from how would you characterize that? If not being in secret, would that be executive session? How would you, you're doing business, doing proceedings that are not visible to the membership. How would you characterize that if not being in secret or an executive session?
It's simply that the debate is not public. And that, as I said, that doesn't fall under the rules governing meetings because they don't apply to email ballots. So one of the problems that was being addressed with this policy manual change was that by the nature of those being public, many of the argumentations put forth by LNC members became performative. And it hampered the business of the LNC, and it made it harder for us to work cohesively as a team. And that was something that was covered in board training that we received with best practices, considering for all kinds of nonprofit boards and political boards and things like that. This was a specific intended change to limit that so that we could do our business in that manner. And with the consideration of one of the statements in the appellant's brief, I think email ballots are generally a bad idea. I don't think we should be having our business conducted that manner. So I don't object to that characterization in the brief, but we do have them. It is in our bylaws, and this is a proposal that is intended to make those more functional. And it also does lead to accountability because, as has been stated, members have been unhappy with the content of the business. And when I published this, when I moved this policy manual change, it was my understanding that we would reduce our dependency on those to things that were simple housekeeping measures. But unfortunately, there's no easy way to distinguish that, and I can't stop other members from making motions. Members are able to debate amongst themselves to consider these things, and we have provisions that allow that in this rule, and it's not blocking debate. As a matter of fact, the rule is structured that if it is requested, it defaults to allowing debate unless there is a substantive objection to it. So these matters are included. It allows the conducting of business. If members are unhappy about the amount of business or the nature of business being conducted with email ballots, I would encourage them to pressure their LNC representatives, and I am working to pressure LNC representatives to minimize that. Upon that adoption, I was given assurances by some members that we wouldn't continue the practice of doing substantive business on that, but that hasn't been honored, and I can't stop that, unfortunately. But in the meantime, I'm here to defend the fact that this policy is in accordance with the bylaws, and therefore it is not in order for the JC to consider, repealing it.
Okay, I think probably one last thing here. I saw on the chat, Ms. Hogarth wrote that if you have different conditions for transparency versus electronic in-person meetings, there will be a clear incentive for unpopular decisions to be made via email balloting. So, is that true? Would that be an incentive? Do you agree that would be an incentive for an end run around the open policy requirement of 7.15?
I mean, you can characterize it that way if you like, but it's our bylaws. Our bylaws allow these motions to be made in either manner. And if people are doing things that the members of the party don't like by moving business or sponsoring business that they think is evading that, then the remedy for that is for members to elect new representatives at our next convention. It's not to micromanage the policy decisions of the LNC within the term via the JC.
I understand that. Okay, I'm done. Thank you, Mr. Chair. Thank you, Mr. Chatterton and other.
And Mr. Tarnoff, I'm sorry that I do have to interrupt, but I misstated something and I do have to correct the record professionally when that happens. Mr. Chatterton is correct that the default is that debate is allowed. So I misstated something and I withdrew my point of order to the LNC. I thank Mr. Chatterton for the correction. I wanted that on the public record because that is my professional responsibility when I said something incorrect.
And I'd like to just ask before you stop your questions, Mr. Tarnoff, that Jamie or Ms. Van Alstyne be able to, she had something to say about that last toll exchange. So can we do that real quick?
Please direct your question to the chair. I'm done. I feel I've had my questions answered, but the chair may indulge if he so chooses.
Okay, Mr. Chair, can she respond to at least some of the stuff because all of the answers were coming from Mr. Chatterton?
Absolutely. I like the more discussion we have, the better, even though we've already been going for a couple hours on this.
Yep. Thank you, Mr. Chair. Thank you, Mimi. So there was a couple of points in Mr. Chatterton brought up, and I'll address them in most recent to the earlier. The fact that the initial motion to remove debate from the electronic mail was proposed by Mr. Chatterton. And if I am going to paraphrase here, but bear with me, it was specifically to the point that email votes would be infrequent and mainly reserved for minor matters, and that the approach would minimize excessive drama in public discussions. However, since January, There have been votes on several significant issues, which he did allude to, including a resolution, the seating of an at-large member, the formation of an investigatory committee to address alleged actions by our recently resigned chair. And furthermore, I want to express my complete confidence in Mr. Michaela's ability to effectively manage the LNC. However, it is crucial to emphasize that members should not be penalized, which I think is his reasoning here for removing this policy from the policy manual. Members should not be penalized for the inappropriate actions of certain LNC members, regardless of how such events are handled. Now, going back to one of the other points regarding 715, I believe it was, and 13, again, we are playing with terms here, and bylaws are voted on at conventions by members, most of which are not parliamentarians. And we have to kind of parse the understanding, the general understanding. And when we talk about sessions, meeting, and business, we have to assume that most members bundled those together. So I don't see the big ambiguity between 714 and 15 and 13. You're clarifying the rules of a asynchronous process that is email in a way to comply with 714.15. Now, that's not going to be perfect, but from my understanding, that is the intent. That is what you're doing with 13, is you're trying to replicate the requirements of 714 and 15. And with that, that's all I had on those.
Okay. And Blair, you are all done, sir?
Yes, I am. Thank you.
Thank you. Okay. Next up in line is me. I just have a little bit here. A question for Andrew. When you say that the email goes out, does it just give the total, or does it say who voted for what?
The email tracking sheet has the individual members' votes listed on there, as well as all the co-sponsors. So, in case that there is disagreement with a given nature of a motion being done on an email ballot, the members can see who co-sponsored that motion. That's included specifically in that. So if they have an issue with the nature of business done, they can take it up with those individuals that sponsored that to be done in meetings. And I think that we're trying to substitute the accountability of elected representatives to the members with attempting to revise the bylaws on the fly by the JC here.
I certainly agree with that statement. I'm seeing a lot of that. People are looking for second chances going through the JC. I'm not sure that I heard an answer to my question.
I'm sorry.
You said that the person who sponsored it and supporting it, that's mentioned, but does it say individually who voted for it?
Oh, yes. The petitioners provided a link to for example, the sheet that had this policy manual adopted, and that provides a reference to the final vote tallies with all the individual votes called out on that sheet. So the email itself includes the co-sponsors, which since it's issued at the start of the motion, and then the tracking sheet provides all the individual votes.
Okay, thank you. That's an answer then. Now, when they're asking for the debate to be done, do you debate on the email list?
I generally would say there's not tending to be debate on those. We haven't had a case that anyone asked to raise debate according to the provision in the policy manual terms. So we haven't had any, but it hasn't been to the exclusion of anyone that wanted to. I think generally that, those motions are going through without it.
So there has been no debate via email?
Not under this policy since it's been enacted on a motion.
Okay. Now, if
I can add to that real quickly,
yes,
I would
please.
assume that I would assume that members who are in support of these motions have conducted, private lobbying for them. There was the example of a motion that was for an at-large vacancy. And that was moved very abruptly after that vacancy was created, and went through without debate. However, I was not in support of that motion. I did not vote for that motion, or I didn't co-sponsor that motion, but all that information about who did was publicly available to the membership. And those things are there, and the recourse for members is to hold those individuals accountable if they disagree with that.
I agree with that too. Well, then, in light of that, Mimi or Jamie, what debate is not being published? If there's no debate going on the email, what's not being published? Either one of you.
Well, the thing is debate used to be conducted via the email and published to the business list. The change in October essentially killed that, whether intentionally or unintentionally. And I would also just like to point out that the policy change itself hasn't even been complied with, greater than what I mentioned earlier, in that only the results of the votes were published, and the votes to the public list, and the votes were captured, and they were captured in a Microsoft product. And at the time, between October and January, sometime in January, members had to have a Microsoft account to access that. So it was totally opaque, unless the acting secretary at the time chose to send an email to make it public, which did not happen. So they weren't even complying with the policy change they enacted in October. But prior to that, debate was conducted via email.
But it's, I'm not sure I heard a direct answer, but it's not, but Andrew just said there's no debate being conducted by email now. So if.
Can I answer that? If there's no debate,
either one of you.
If there's no debate if there's no debate, whether it's a public list or a private list, there's no debate. If there is no debate, I don't understand the LNC's reasoning for not putting it on a public list. But if it was a public list and the members of the LNC decided just simply to vote and not debate, that would be their prerogative. We're not saying that we're forcing them to debate. He's saying that there isn't debate, but the membership has no idea that that's true, because it's a private list. It's a private group that the membership can't see. So it's not complying with what was done prior, which was that even if there was no debate, each member of the LNC would cast their vote. So if it's nothing other than saying, I vote A, I vote I vote nay, that would be the email. If they have something to say about it, that would be what would be in it as well. If it's something very simple, as Mr. Chatterton suggested, like approving minutes, I would imagine that the only debate that would happen would be maybe a correction to the minutes to say, oh, I just saw this thing. But him saying there's no debate still doesn't tell us there's no debate, because we can't see it. And I believe that the bylaws, he keeps stressing on this whole sessions thing. I think being that it says in the bylaws that all votes are conducted in open session, and being that a email motion is a vote, and being that I was at the convention when we passed that bylaw, and my understanding was that that was going to be the case, because I didn't differentiate the fact that they didn't put the word session in there, or they didn't call emails a session or so forth. I think most of the membership believed the same way I did when I voted on that. So I just wanted to if there's truly no debate, then we'll see there's truly no debate, but we will see the votes in real time.
Would a statement that there has been no debate be sufficient? I'm sounding like Blaine now. I'm solutioning. But is that what you're, if there's
no, I'd like to, what we're saying is that we want to be able to see the actions of the committee in real time, which would be on the reflector email list, not a list that membership can chime in on, but one that we can see in real time. And then they wouldn't have to say there was no debate, because we would see there was no debate.
Understood.
We would see the vote.
I guess I go back to Andrew on that. Why wouldn't you want that that email debate to be available? Why have a bylaw saying it doesn't have to be?
Well, there is no bylaw stating it doesn't have to be, or
A
have to be
bylaw
for that matter. But
motion.
the consideration comes down to how it was being used and how that impacted the effectiveness of the LNC. There was a documented, pattern, I think, or maybe not documented isn't the right word, but there was a consistent pattern of people using that public list to grandstand their positions, to try to hamstring the LNC, to cast, doubt on decisions that had been reached by the body. And that was found to be not consistent with best practices for having an effective organization.
Okay.
Um,
These people who would have these additional comments, were they LNC members or from the gallery?
Yes, it was when the business list was publicly held that we had all the emails back and forth that were just immediately mirrored. Effectively or not effectively, specifically what the petitioners are asking to go back to. Um, the debate was used not really to debate motions, but to grandstand and then refer other members to that so they could try to, in the opinion of many board members, undermine the ongoing business of the LNC. And regardless of whether or not the petitioners want to acknowledge this, is the members of the LNC are conducted to run the affairs of the party in between conventions.
Yeah. I'm not sure I heard an answer to my question. Boolean question. These people on the email list that are grandstanding, are they LNC members?
Yes, those are the only individuals that had access previously to that
Well, let
list.
me follow up. Why are you trying to silence LNC members on their debate on something that you call grandstanding?
Well, that was agreed upon by I think 2/3 of the LNC that was not conducive to effective conducting of business by the LNC.
Okay.
And it was decided within the bounds of our authority to amend the policy manual. Those requirements to do that, despite what the members of the petitioning team have said, those requirements only existed in the policy manual, which is completely within the authority of the LNC to amend as they see fit according to the rules that were followed. We had, I think it was a 10 to 4 to 1 vote to adopt this provision, which makes it a binding decision of the LNC. So the considerations around that, I think supersede, the consideration of, just like you can vote to end debate. This was adopted as a special rule of the LNC to limit the ability to grandstand publicly, that we conduct our business via, discussion along the terms of what are allowed under the bylaws. And certainly my preference would be that we do less and less of that by email ballot. We do it in meetings, because not just was it, recommended in the board training that we had, the grounds for that were that email is a very inefficient and ineffective way. It doesn't allow the nuance of hearing someone speak. It doesn't allow, so even if you do publish that, you're losing much of the value of things that would be conducted in a meeting. So it would, I think the LNC should move towards, less and less business of that. And as I said earlier, I was given assurances that that would be done, and it hasn't happened, which I'm not thrilled about, but it's not an indictment of the policy. It's the fact that certain individuals are not doing that. And, the list publishes and says who those individuals are, and the prerogative to deal with that is to lobby to have those people not elected at the next time they're up for election.
Okay. Yep. Okay. That answers all my questions. And I feel your pain, sir. We have the same problem on the Judicial Committee. All right. Next up is Mr. Montoni. Mark, you got any questions? First to Mark.
Mr. Chair,
Yes.
I do believe Mark stated that he might be working and not be able to actively participate, but he would be listening in.
All right. Well, if he shows up, he can ask questions. In that case, we shall then roll down the line. Mr. Seebeck, you're up.
I will defer back to Mr. Montoni if he pops in, just because of his because of what's going on. But I do have one question for Mr. Chatterton, and this is something that I think it's right at the core of the matter, and it's a very simple question. Why is there so much of a adamancy for all this secrecy? It doesn't make any sense that as an organization that is run by its members, who delegates authority to leadership and ruling body such as the LNC to suddenly have all of that activity by that delegated body be cut off from the people who had delegated them to do the job in the first place. How can the membership have proper oversight as to what's going on with the people that they chose to do the job if they're being cut off from being able to see what's going on? That to me is the core of the issue here. Why technical issues of bylaws and definitions of sessions and so on aside, that's the core of the issue. Why is there this push? Why is there insistence to deny members their right to see what is going on in their organization?
I would start off just by rejecting your framing of the question. Members are not being cut out. They are not losing that right. They have the ability to see what is going on. The assertions of that are based on flawed interpretations of the bylaws that don't justify the claimed rights that are being demanded by the petitioners. It is not the right under our bylaws to have access to all that information. And this policy manual provision was put in place because that, as you stated, the LNC is elected to lead the party between conventions and is accountable to the membership at conventions and through things such as the appeal process. However, though, that does not take away the LNC's authority to exercise its judgment on how to best conduct the business of the party. Members have accountability of the LNC have accountability for that based on their sponsorship of these motions, their votes on these motions, which are all made public. So those rights are not being deprived. And so your question is flawed in that. So I don't know that I can give an answer to it, but hopefully.
As someone who has
that
been in this
addresses-
party for 25 years and has seen past attempts by the LNC to engage in secrecy only to have it leak like a sieve, exposing chicanery to the membership, I think that your rejection of my question is out of line because we've seen it before. We've seen this history repeat itself multiple times. And it was that same attempt in the past, which has led to things which included the removal of certain members of the LNC at the convention by overwhelming votes in the past because of that those activities. The membership over the past 25 years that I've been in the party has overwhelmingly been in favor of full transparency for what its leadership is doing in order to have its own oversight and say through its representatives on the committee as to what is going on. And that applies not only to in-person meetings and conventions, but it also applies to activities on the business list beyond just votes. So the claim that there is no right for the members to be able to inspect that doesn't make any sense because the history of this party, the fundamental bottoms-up nature of this party, and the nature of it being a membership-run party contradict that. That's all from me.
I would ask you to point to the reference in the bylaws that's in contradiction of. There's not one. I've elaborated thoroughly through my arguments what the bylaws contain, and the bylaws are what define the rights of the membership. So as has been already established, there's nothing being withheld and held behind secrecy here. The votes are public. If there is debate, it can be incorporated, but no one has asked for debate. There's nothing being withheld in that regard. So the assertion that this is hiding chicanery or whatnot is a baseless assertion. This doesn't have any correlation to anything being withheld or anything being kept secret. It's a matter for how the LNC can optimally conduct business. It was implemented through its allowed procedures of amending the policy manual. The requirements that you're saying constitute an obstruction of the ability of members to have transparency only existed within the policy manual. They were not implemented by the convention. And regardless of statements that people believe those to be the intent, I've already stated how it is absolutely the right of a member to be able to look at the bylaws and interpret them based on their clear language on what they mean. So the assertion that because it was done this way, that it is a rule that it has to be done this way is flawed because you're trampling the rights of members to being able to have a clear and understanding of the bylaws. If there were an ambiguity that was calling for that information to be made public, then that would be a different question, but there clearly is not. And regardless of whether the members in the convention chose to implement the word session or not, is simply a matter of that's the responsibility of the delegates of convention to make sure that they're writing bylaws proposals that accomplish what they intend. And if they fail to do that, that problem is not on the LNC, it is on the delegates at the convention. And that emphasizes the importance of having skilled and knowledgeable people, help prepare bylaws. So these are all issues that you're raising that have nothing to do with this case and have no bearing on whether or not this decision of the LNC should be upheld or overturned.
I disagree with that, but that's all from me, Mr. Chair.
All right. Thank you very much. Looking next on the list, Mr. Stratton. Has Mark gotten back to us yet? I see not. Okay. Mr. Stratton, you're on.
Well, I had 7 pages on a small notebook of questions, and almost all of them were taken care of.
Yeah. I would agree, and I'd thank the other Rob for that. He did a very good job.
Yeah, Rob and Blay are very thorough. I appreciate them a lot. So I did have a question just for clarification for Mr. Chatterin. So on the votes on the electric on the email, are they voting by email, or are they voting and then that's being put onto a word sheet and put into the email?
Can you please clarify the question? Is that about the votes are on the internal email list and then they are reproduced on the public tracking sheet? Did that answer what you were?
Yeah, so each member of the LNC are actually voting in an email, and then later that's put onto a spreadsheet.
Correct.
Okay, yeah, I just wanted a little bit of clarification for that. Let me see, what else do I kind of have written down here? Shoot, where's my yeah, I think almost everything else was covered as far as my questions for the defense side. On the petitioner side, maybe no, it's more of me just pondering, and again, it's not really relevant to the decision. It would be what people would like to be seen. So I think I'm done, Mr. Chair.
All right. Thank you very much. Still no Mark. Okay, we can go back.
Mr. Chairman, I do see a Mark Montoni too that's unmuted, and I'll just also indicate he did communicate through our list that he had to, I know he had another obligation later today, but he might be listening. He did say he was going to listen, but he might not be able to question. Just want to clarify our record there.
Oh, here you are. I just got it. He just texted his mic is not working.
Okay.
And Mark, you can type a question into the chat if you like.
Mr. Chair, I'm working on transmitting that for him momentarily here, if you'll bear with us a moment.
Yep, I can. Is that going to take more than a couple seconds?
Hopefully not.
Because what I was going to do is we now go back to the top of the batting order for JC questions. So Rob Latham, while Mike is getting things set up, do you have any additional questions?
Well, in looking at the chat, I see Mr. Jacobs says he has an answer for my question on this. Can an organization basically adopt a policy that contravenes laws, statutes, whatever? And I see Mr. Tarnoff has even posted a link, so I'll look at that as well. I asked Mr. Jacobs just a point. Let me look at. I'm going to defer and look at those 2 quoted provisions, and then maybe wait for Mr. Jacobs to respond in the chat. So maybe if I still need more clarification, I'll do it the next go around.
Mr. Chair?
Yes, I see it. Do you want to read it?
Okay.
Okay. Mike, do you want to do it? We have something in the chat from Mark.
Yeah. Do you want me to speak it for him?
Sure. You could be our virtual Mark.
All right. I will be temporary Mark. Whoops, hang on. The scrolling disappeared. There we go. I just read this as it's written. Mr. Chair, besides needing to leave shortly, my mic doesn't seem to be working. Only questions I had. One, the possibility of losing data was known. Failing to both test for it, much less allow it on the part of either the LNC or staff, should have carried consequences. Why were there no consequences? Two,
Why don't we
regard,
pause there? Why don't we pause there, get an answer to the first question, and then we can
All
go
right.
on the other ones. I guess that goes to Andrew.
I don't know that there was a known risk of that. So I don't know that I can adequately answer that. I wasn't directly involved in the conversations about the technical implementation behind that. I did pull up some materials earlier that clarified, what information was missing if the JC would like to hear about that. But as far as I'm aware, I don't know that there was a known risk for that. And the statements at the beginning of the hearing about information prior to the Microsoft transition, I have the list that the last email involved, says that we're making the switch and we're switching to a new list. So I believe that list still exists. That's the LNC business group. And then there's the LNC business list public group that exists on the new system after the migration, which is the one that is cited by the petitioners. And as far as I'm aware, that was not subject of Mr. Nikela's statement about lost information. So I don't know that there is anything lost, but I don't have the full details on that. Hopefully that indirectly answers that.
Okay.
Or fails to answer that, but tells you what I know of it.
Next item, number 2, this looks more like a comment. Regarding that matter as having been mooted, I still consider it relevant until such time as all corrective action has been done. Number 3, Mr. Chatteron claimed at one point in this hearing that, quote, members can see how members are voting and can try to influence their LNC reps, unquote. Explain how that can be done. Time travel, question.
Certainly it's not a question of time travel. The ballot is sent out when the motion is sponsored. And it has a list attached that shows the votes in near real time. And I know it's not quote unquote real time, but it's a 7-day ballot. And I've seen numerous examples that the secretary is updating that several times a day, usually within hours. And I don't think I've ever seen a case where it's gone more than a day after a vote was cast, but they can certainly see that the motion is active, independent of, even if they don't see what their specific representative voted for. But that notice is out there from the time the ballot is opened until it closes, and it's updated regularly with the status of votes during the conduct of the ballot. So members have the ability to see that publicly and contact them while the vote is still in progress.
Okay, that takes care of Mark's questions. Thank you, Mark, if you're still listening. We are in the second round of JC questions, batting order. Mr. Kinsella, you're next in line. Is he still here?
I see him here.
He's here, but he's muted. Maybe
Okay, yes,
unmuted.
yeah, can you hear me?
Yes.
Yeah, I have no further questions.
All right. Again, going down the line, Mr. Tarnoff. And behave.
I believe Mr. Kinsella was next.
He just said no.
Oh, I say no as well.
Okay. I have no additional questions. I think Mark is probably all questioned out. He can chat us if he wants to jump in there. If not, we'll go back to Mr. Seebeck. Mike, any secondary questions?
Nothing further from me.
Okay. And rounding out the batting order, Mr. Stratton.
Yeah, I have one question, and forgive me for not asking earlier, but I saw in the I thought it was just covered, but it seems like Miss Van Alstine disagrees. She wrote in the chat, votes are published on the once again public motion spreadsheet, not in real time. But then this says this wasn't true between October and January. So Ms. Van Alstine, can you clarify that, please?
Yeah, absolutely. So between October and sometime in January, the only notices that went to the public list were the completion of a vote. The votes themselves and the motions were not made public. They were tracked by the acting secretary, but they were stored in a Microsoft product, either OneNote or SharePoint, from my understanding, which is only accessible if you have a Microsoft account. So to me, they weren't complying even to that degree. Now
All
we are seeing a Google Sheets that the Secretary Harlos is including and is accessible to all members, which do track the votes, but they're certainly not real time, which is one of the reasons I argue that that Article 13 exists, is it tries to accommodate the requirements in 7, 14, and 15 in a format that isn't asynchronous.
So are you saying that the LNC members are not voting in real time on their emails, or they weren't only for that time period of October through January?
I am sure they were voting real time, but the access to those votes was not. That is, the motions weren't made publicly available prior to the vote completion. The votes themselves were occurring. And my understanding is also that debate was occurring in the emails. But again, I can't confirm that because they were not public.
All right, thank you. No further questions, Mr. Chair.
All right. Last call for JC questions,
I have two.
at least. Go for it, sir.
Okay. So kind of, yeah, following up on this issue of, I think I heard Mr. Chatterton, you say that because the secretary is posting these tables, tracking votes, that satisfies the LNC's obligation to do these in open session. And then I think just in the discussion I'm seeing, is there a bylaw that requires the LNC to do that? Like, if the secretary stops doing that, would that still be bylaws compliant? I guess that's my question.
I would correct the understanding. So I would not have previously associated the email votes with anything related to the requirement for open session. But I think essentially the actions that are done are that the ballot is reported, and at the conclusion, the results are reported. Those are the items that are required under the bylaws. The real-time reporting of that, I think, is exceeding the requirements of the bylaws, and it goes beyond the requirements from the bylaws to provide that transparency. So I further reject all the assertions from the petitioners that this is an action that is making things making things lack of transparency or this wall of secrecy. We are exceeding those bylaw requirements and doing that. And I assume that the secretary intends to continue those actions. But I would certainly have no objections to, amending our policy manual in the future to say that that should continue to happen. I think that's a very reasonable request to see the vote results. And that wasn't addressed in the policy manual provision because it was happening, but there is no requirement for that in real time during the votes, but only at the conclusion of the ballots. But I think the provisions that have been mentioned are still completely valid under that consideration, is that the membership of the party is notified when a motion is started and when a motion is completed, and they can see everything in that. And so if people were wanting to call for a certain outcome for that, they can know when that motion started and they can be in touch with their representatives. We should not consider, the assumption that essentially that entire burden is outside of the obligation of the members to be informed about what's going on in the party business.
Okay. Thank you, Mr. Chatterton. I'll kick it to Ms. Van Alstyne, and then if she wants to defer to others that have been assisting her as well.
And I'm sorry, I kind of lost track there because I was responding electronically, since it seems to be one of the ways that I can get through.
Do you want me to restate my question?
Please.
Yeah, I heard Mr. Chatterton say that the LNC is meeting its obligations to comply with 714 and 15 by posting these motion spreadsheets and tracking that vote. Does not need to be done in real time. And so my question was basically, does the LNC, do the bylaws require the LNC to do even that? And I don't want to mischaracterize his response. Hopefully you heard his response, but what is your argument on whether the bylaws require the LNC to do even these tracked votes on the spreadsheet?
Well, I don't know that it explicitly states that, except for that it requires that votes and actions in 714, and if I scroll up for a moment here, (715) explicitly, the National Committee and all of its committees shall conduct all votes and actions in open session. Now, I think, again, tying back to Article 13, is its attempt to tie electronic balloting to this requirement and how to best do that. It can't be necessarily in real time without publishing directly to unless all of us have access to those votes as they're occurring. We're getting those emails, which we aren't, and we're not asking for that. But in a timely enough, the requirement would mean that we have enough time to respond to what is occurring and then reach out to our district reps, our at large, our officers on the potential motions before they're concluded. So okay. I think we're trying to get as close to real time as possible based on the limitation of the technology.
Okay. And then, so, I've been querying about this issue of whether our bylaws allow an organization, or our parliamentary authority allows an organization to engage in stuff that would maybe be deemed illegal or in violation of, a law or whatnot. And I'll say there's an interesting discussion on the Roberts Rules Forum about the Bank Robbers Association and conducting their business by Roberts Rules. So people can look at that at their own at leisure. But teasing that out, it sounds like the distinction is between whether something is procedural, whether an organization is doing something procedural or non-procedural. So Roberts seems to say that procedural activities of an organization must comply with state laws, codes, whatever, but non-procedural stuff, maybe that's a more open question. So kind of to both of you, I'll start with the petitioner. I'll let Mr. Chatterton or the LNC or others. So is this challenge policy manual provision, is it procedural or non-procedural? And if you could elaborate as to why or why not, that'd be helpful. And I'm going to go to Ms. Van Alstyne, and I see a red microphone, so you might be muted. You might need to unmute.
Yes. If neither you nor Karen Ann has any objection, I would defer to her if she'd like to speak to this more. She has more familiarity, I believe, than I do on this.
All right. Looks like she's unmuted too.
Yeah, thank you. I would want to make clear that it's my understanding in the petition, because I'm not saying this to disrespect you at all, so please don't take it this way. I don't think anyone is claiming that the LNC is not complying with any law. The law was only cited to show that actions under DC law were understood to be more than mere, not just a formal vote. That actions could be taken without a vote. That was the only purpose of citing it. So it was for a definitional purpose, since that's the body of law that the LNC is bound under. I think a lot of times been consumed by that law that, and it was never argued by either side. It was merely argued to show that actions are different from votes. That was the only purpose. Nobody is claiming the LNC is violating the law here. It was just a definitional thing.
Okay, appreciate that clarification. Do you want to speak to whether this topic that's the subject of the appeal deals with a procedural or non-procedural matter?
And I think Mimi, whose appeal it is, might slightly disagree with what I just said. So, you know, she would be the final word. That's just my view. And so I'll pass over to Mimi. I'm not sure I understand your question, only because, again, I'm trying to say this with respect. I've had a really long day. Because I don't think I understand your question because I don't understand the significance of it. I think this is what it comes down to. The LNC had a certain practice from 2014 up and through August of last year. The delegates understood that process. There was never any complaint at the 2016 convention, at the 2018 convention, at the 2020 convention, at the 2022 convention, that they were dysfunctional in some way because too much stuff was being shared, that there was any issue with the bylaws. The LNC could have asked the delegates for clarification. So the delegates, with our current bylaws, seem to have a right to be secure that the LNC has interpreted a certain way. They were comfortable with it. It hasn't been an issue. And it seems to be that at its last amendment, in adding actions, they were like putting a double padlock on it. And I want to make an analogy here where Mr. Chatterton has made a technical argument. And again, I am not disparaging him or doing anything of that sort, but going to what was the intent of these bylaws. If you remember in 2018, but this goes back to an argument before, some bylaws committees had made the argument that the statement of principles should be able to be amended by a three-step process, that 7/8 was never really intended to lock it down forever because the bylaws said the bylaws could be amended by a 2/3 vote. And then the next bylaw said, however, section 3.4, I think is what it was, but I could have the section, can only be amended by a 7/8 vote. But the bylaws didn't say that bylaw could only be amended by a 7/8 vote. So there was these sneaky tricks over the years to try to do a three-step process in order to circumvent that 7/8 rule. And I think everyone understood that was never the intent. The intent of the 1974 delegates was to padlock the statement of principles. And I think chairs rightly declared those motions to do this three-step process. Though a parliamentary argument can be made that it was technically correct.
Karen,
I am getting to the point. I'm going to tie it together. I think the same thing is happening here. The intent of the bylaws and the delegates, I think, is really, really clear. And a technical workaround is trying to be found. And I think at times we have to honor what our membership wants. Our membership obviously wanted transparency, and they wanted even more by adding in the word actions. And it's the job of the JC to uphold the will of the delegates in the bylaws. I am not poo-pooing Mr. Chatterton's technical argument, but I just do not believe that's what our bylaws mean. But I am not saying he is making invalid technical points whatsoever.
The point has been made.
Thank you, Mr. Chair.
So, hey, I'm in a meeting, sorry. Just so I can make a good record here, bottom of page 6 of the petition, remedy requested, and so setting this up for Ms. Robson to maybe help clarify. It just asking, it's this decision of the LNC to take all business off the public list, including the actual debate and actual votes, except with the session of executive session. So that's my question again, is this decision that's being appealed something that's procedural, or non-procedural? Because I think we could even take the DC code out of it, because again, that might help us as a committee, judicial committee, decide whether this complies with the bylaws or does not. So that's the question.
Okay, so I think I understand your question. And what I was going to say I slightly disagreed with before was that although it wasn't the original intent to say that they're doing anything in violation of DC law, it could be construed that they are, because DC law does require actions to be done publicly, right? But we're saying that this is, you're asking, is it procedurally or?
Yeah, was it LNC's decision to take business off the public list, email list, including the actual debate and actual votes, is that a procedural action by the LNC, or is it a non-procedural action by the LNC?
Well, I would say it's a procedural action of the LNC. They made a decision in that vote, which was absolutely an action to do something that takes other actions off of the public list. And at one point, somebody had said that there was no requirement for even votes to be recorded in real time. I believe that what the delegates had anticipated was, between bylaw 15 and 13, I don't have the section in front of me, that those would work together, because it is in fact votes happening. And so I believe that the delegates felt that that was public session, which would mean you need to have as much of the deliberative process as possible, which would mean, I guess procedurally, those votes would have to be publicly available in real time. A spreadsheet not only is not real time, but also isn't just going to the membership via an email. You have to then take an extra step and go online and find the spreadsheet and look at the spreadsheet and go back to it daily if you so wish. But if you're not seeing when the people are voting, you're not seeing that even the votes in real time. So yes, I would say it's procedural. It's procedurally wrong, I guess, is what I'm saying. Okay. And Miss Van Alstine has something to add to that, but that would be what I believe I was asking in my appeal.
Okay, and I do want to come to Mr. Chatterton, but Ms. Alstine, anything else to add there?
No, I think both Ms. Harlos and Ms. Robson covered the topic.
Okay, how about you, Mr. Chatterton?
I would generally echo, I think, what Ms. Harlow said about not fully understanding the implication of that. It would generally, I would reserve the right to reconsider my answer in light of a future, clarification of that. But it would seem procedural to me. But with that disclaimer,
I'll just, for what it's worth, I'll throw my just hot take. It seems like procedural means that the LNC's policy does have to. It can't violate DC code, but if it's non-procedural, then the LNC has more leeway to do something that's not in concert with DC code. I don't know if that changes anybody's response or take, but that's just my kind of hot take on that distinction. Anybody want?
I would want to better understand like DC code definitions of that, but I would also just add to reiterate my earlier point is I don't see any violation of DC code, especially with the consideration of the record keeping requirement that doesn't provide for any disclosure requirements along with that. So,
okay, that's again all I have this round, Mr. Chairman.
All right, penultimate last call for JC comments before we go into closing arguments. All right. Going once, going twice, sold. Moving into closing arguments on the final stretch. For the appellant, 5 minutes, please, all yours.
I don't think that I will take 5 minutes, but let's see what I can do here. I'm just going to go back and I'm going to restate a couple of things as I stated in my introduction, and that is this appeal is about compliance with our bylaws. I believe that Article 13 is just procedural in that it tries to accommodate the requirements in 714 and 715. That the policy manual itself the open emails portion that was deleted from the policy manual in October was just a codification of the practice of the LNC since 2014. And that had never come up for substantive debate at any convention with the delegates. It's about the fundamental principle of transparency and accountability that those bylaws represent, and that should govern our party. And we urge this committee to consider those implications in allowing the LNC to continue to operate without proper oversight, which I believe the current, the status quo is. Every member of the Libertarian Party deserves to know what actions are taken on their behalf, provide input, and to hold those representatives accountable for those actions. I request that the JC grant the remedies requested in the appeal specific to email balloting by ordering that the LNC return to its prior practice of having all votes and actions, and that is everything that relates to business, including debate, on the public list, and to restore the previous email lists to the extent possible. And if I have extra time, if Ms. Robson would like to add to that closing statement.
Yeah, I always like to add is to thank the Judicial Committee very much for giving up over 3 hours of their time on a Saturday afternoon for hearing this, and I really appreciate it.
All right.
Nothing.
Is that it for the appellants? Very good. Didn't take 5 minutes. Respondents, 5 minutes.
Thank you very much. I would also thank the Judicial Committee for their time today and hearing the arguments and discussion. I would basically close my case by asserting, as was iterated through my arguments and through the discussion today, the actions being complained about are not violations of the bylaws. They are disagreements with what the petitioners view should be the policy of the national party. The petitioners are selectively trying to amplify certain things they believe are rights at the exclusion of other things that are rights. I would emphasize that the delegates at convention have the right that their elected leaders should be able to lead the party under the judgment of those leaders, within the provisions for checking the actions of those leaders that are allotted. One of those is to evaluate the decisions of the LNC if they are compliant with the bylaws. And this has been shown to be completely in compliance with the bylaws. The only thing that is in dispute here is what the petitioners believe should be our bylaws, as they have repeatedly stated that they think that these things should be, an expansion of the definition of a session. They have provided, however, no substantiation for that. The contents of the bylaws are governed in their interpretation by the parliamentary authority that we adopt, which gives specific rules for how that interpretation happens and how you assess ambiguous bylaws. We've clearly established where there are ambiguities and where there are not. And the conducting of electronic ballots does not have any ambiguities in its process. There is the one about whether electronic ballots should exist at all, which was stated by Ms. Harlos as an absurd interpretation. If it were to be assessed that they were not in compliance, because there is a specific statement allowing for them, which I completely agree with that. I think that would be an absolutely absurd interpretation to say that they are not, but that does not provide for the fact of expanding the definition of a session, which our bylaws make no attempt to do. It provides specific examples, as I illustrated, that distinguish electronic ballots from a session, and doesn't have any evidence to say that this should apply. It makes several specific items that I highlighted in my brief otherwise. The considerations around the members being locked out of business are completely false. Members have full access to see the business being conducted. They have full access to see who sponsored a given electronic motion. They have full access to see who voted for a motion. They have full access to know when a motion starts, that they can lobby their representatives during the conduct of that ballot. They have the ability to see who voted for a ballot if it was in contravention of their stated interests as a member of the party. The claims against the transparency are baseless. This is simply a matter of the LNC has chosen to conduct its business in a way that is in compliance with its bylaws that the petitioners don't agree with. And therefore, it is the obligation of the JC to reject this appeal and allow the LNC to conduct its business according to the bylaws throughout the rest of the term. The statements that have been made saying there are exceptions to things being followed for that are claims of individual violations of this policy, not deficiencies of this policy itself. So if people believe that certain motions were not made public, then that is a separate issue to be addressed, or it is something to be considered in their choices for representatives at the next election. But this is not a matter for the JC to decide, grounds for the JC to decide that this policy is not appropriate into the bylaws. That has been clearly established that it is. The arguments around the intention do not hold water. The rules around that clearly state for that. And again, emphasize the point that the LNC needs to be able to conduct business according to the best practices of nonprofit boards and of boards in general. And the clear guidance of that from an industry expert is that email ballots are absurd in the first place, and trying to do this business that way is not the best interest of the party. And beyond just the obligation to the members, our duty of the LNC involves to pursue liberty. It's the thing stated in our principles. It is not just to do the bidding in real time of people who are not aware of all the details of what's going on and all that. We should be accountable to those people. We should answer their concerns. But there are minutiae of business that gets conducted throughout the work of the LNC that takes, judgment beyond that. And so to have all the arguments raised tonight that are like, we don't think it should be this way, don't hold water. And I'll close my comments there.
All right. Sounds good. Then that's the closing arguments. Next up on the agenda is any final questions or comments from JC members. And we'll start off with Mr. Latham.
I got nothing else, Mr. Chairman.
Okay, Mr. Kinsella.
No, I'm fine.
Thank you. Mr. Turnoff.
I'm good. Thank you.
I am good as well. Mr. Montoni, number 1 or 2.
He's left.
Okay. Mr. Seebeck.
I have nothing.
Okay. Mr. Stratton.
Nothing further, Chair.
Here you go. With that, we have concluded. So according to our agenda, next up is adjourn. So I hereby declare this hearing adjourned. Thank you all for your time.